My lord, under compelling circumstances, my lord, I'm mentioning item number 32, that is at West Bengal Judicial Service matter. The lordship was pleased to hear the matter on 2nd of December, kept on 3rd of December. It was there as item number 32.
What can be done?
Due to
We
paucity
have
of
come at the fag end of the examination.
Your lordship, my lord,
Notification was issued in August.
no, my lord, it was due to paucity of time, your lordship could not take up this matter. My lord, 7th is the date. 6th is the, my lord, Saturday.
Did the examination be held? Then
No, my lord, there is a
and it is taken up. Tomorrow is the application date.
No, that is why I'm saying, my lord,
Yesterday
today.
there was an original side matters.
Yes, I understand, my lord, due to positive, my lord, kindly today, if your lordship kindly takes it up, my lord, your lordship has considered at length. This is your lordship's order also.
That I know.
Yes,
I
my lord,
remember.
there is an urgency. I prayed for interim order.
Come at the fag end.
No, my lord, I have come, my lord, before the examination. Kindly, my lord, 2024 is also there. Kindly takes it up today, anytime subject to lordship's convenience. I have served notice also as your lordship directed because they did not appear on the last occasion. State appeared, the High Court administration appeared, I appeared, my lord. They remain unrepresented. On that day itself, I served notice, my lord. There's an urgency. That is why I have come before your lordship, my lord. There's a huge impact on this matter, my lord. Kindly, subject to lordship's kind
Why you
consideration.
have come at the just before the examination? August notification that I asked you.
Yes, my lord, I understand because 2024 is also there.
All the arrangements are made just before
only the form
one fine morning writ petition is filed.
No, my lord.
It's an August notification of 2025 August
My lord,
notification.
there was
September, October, November, December for 4 months you sat tight.
there was a
Then November
discussion.
or November you have filed.
It's November.
Probably on 25th November.
25th November. There was it was not on records, but there was a discussion that this matter could be considered in respect of the Supreme Court's judgment. We have been waiting for that, but nothing has happened. It was only
13th
this
August was the notification day.
Yes.
So now before that on 20th or in May 2025 Supreme Court judgment came.
Yes.
And you filed the writ
But we were
petition on
waiting.
25th November.
Possibly that would be amended. We have been waiting for that, my lord. That had not happened. That is why, my lord, it took some time. The departmental issue, my lord.
Time
was not-
constraints is there. If ultimately court is satisfied, court will pass an order.
Yes.
Preponement
only-
is not
no,
possible. All
only-
matters are in the
I
supplementary.
understand. There is an urgency. There is a come, my lord. My lord, there is only form fill up has done, my lord. Nothing else. Only form fill up has been done. 7th.
The examination is scheduled
Sunday.
in the Sunday.
Yes.
And you have filed on 25th November. You had ample time to
Yes.
move this court.
Possibly that was under consideration. That is why, my lord, it took some time for us to approach because, my lord, understand he is also a participant. He would not like to go against the authorities at this. Your lordship
After
understand this.
publication of advertisement, Mr. Lahiri, nothing remains.
No.
There is no room left for consideration.
My lord, we need to give effect to the Supreme Court's order, my lord. Kindly appreciates that the urgency.
At the fag end, all arrangements are made. What will be done?
Arrangement, only the form fill up.
Let the examination, if it is matter is taken up, taken up.
Yes, in case
examination is held, then after examination matter.
May I request one thing? At least tomorrow at the top, my lord. At least subject to lordship's kind. If today it is not taken up, or 2 p.m. today, any time, my lord. Because otherwise there is an urgency. Large number of candidates are affected by this, my lord. That is why I have come. And my lord, your lordship knows SP Gupta's judgment also.
You want to stall the examination? Nothing else.
No, my lord. Whatever the Supreme Court's judgment, my lord.
There is a Supreme Court
judgment. That is why I have come. And my lord, kindly consider. Your lordship knows the SP Gupta judgment also. Any advocate can come and make lordship's judgment. Lordship knows SP Gupta.
In a fashion, this has been filed and moved. That does not appear to be.
There was some time constraint, my lord. Kindly appreciates, my lord.
Appear to be very acceptable proposal.
I understand, my lord. My lord, there is some time constraint, my lord. Kindly appreciates, my lord. Kindly say, takes it up 2 p.m. or, my lord, I beg of your lordship's kind consideration. Otherwise, my lord, this matter has a large implication. It has a Supreme Court's order is staring at us. My lord, kindly appreciates, my lord.
Yes, that will be taken care of.
My lord, by
when
that
the matter
time,
will be taken up,
yes,
that will be taken care of if respondents cannot satisfy. The appropriate order is
by
to
that
pass.
third party right may be created, my lord.
Third party right. It will take long time. It's a preliminary examination.
Yes, I understand.
Thereafter, MCQ, the written test, and
Interview.
then interview. It will take long time.
I have
You
come.
need not be worried.
My lord, since I have filed before the exam, my lord, kindly takes it up tomorrow, my lord, subject to lordship.
What is the application date?
In keeping it fixed at a, my lord, to be mentioned or anywhere, my lord, subject to as urgent motion, my lord. Kindly, otherwise I would not have usually don't trouble you.
There is much time. Ultimately, if court finds that no, this selection process cannot survive, court will pass an appropriate order.
No, his participation will be clouded.
Not that on 7th everything will be
No,
complete.
he cannot
Everything is
participate
a preliminary examination. He may not participate. He has not applied to how he can participate.
because he cannot challenge at the same time and
Yes, that will
participate.
be considered. If selection process goes, then again he will participate.
Fresh
This
recruitment,
banner
your lordship.
cannot be taken up. Sorry, Mr. Line.
But if your lordship can kindly.
This is item number
32 today. 30.
30.
Shochin. Yes, today is item number 30. Your lordship wanted to hear this yesterday.
Which item?
30. Shayan Shochin Basu. 30.
Have you served notice upon Public Service Commission?
On that day itself, as your lordship, because your lordship wanted to hear that matter tomorrow. Your lordship
Inform at 12.
at 12. I'm informing.
Today at 12.
I permit to mention lordship with
Order.
I permit to mention lordship one matter.
Today is not the mentioning date.
For
It's an extremely urgent matter. Examination is scheduled on 7th. That's why I have heard. Mention on Monday.
I am seeking your
Yes.
lordship leave to file this application.
No leave is necessary. This court indicate the date of date the matter is to be moved on that day. Matter will come.
Unless you
Sorry.
let me leave.
Yes, call the list.
Lordship, it's not the day of mention, Lordship.
Mention on Monday.
Lordship, may I only take 5 seconds?
What is the urgency that you cannot wait till Monday?
The urgency is that, Lordship, the petitioner's promotion, Lordship, is going to be hard. Is going to start it in this month.
Very well.
This month.
Mention on Monday.
Lordship, it was one mention.
Mention on Monday. Sorry, refused.
In the combined.
Please
record.
call the list. Item number 1.
I'm appearing for the respondent, lordship.
See the non-prosecution matter I mentioned to your lordship, directed to serve a notice to the other side. I have served the notice. This is matter for non-prosecution. Petitioner do
You are
not.
for the
Respondents, lordship.
which respondents?
Everyone.
Union of India or state
Yes.
respondents?
Union of India, lordship.
You don't have any objection.
No, lordship.
Issue. Matter has come up in the list under the heading to be mentioned, quote unquote, on being mentioned by the learned advocate representing the petitioner. Next paragraph. Learned advocate representing the petitioner submits that petitioner does not wish to proceed with the matter. And in support of same, a letter dated 1st December 2025 of the petitioner is placed before this court and same is taken on record. Next paragraph, respondents are represented by learned advocate. Next paragraph. In view of aforesaid submission, writ petition stands dismissed on the ground of non-prosecution. Stop. Interim order, if any, stands vacated. Parties to act on the server copy.
Grateful, your lordship.
Next. Item number 2.
I am appearing for the petitioner, your lordship, in this matter. As per my lord's direction, I have submitted the deficit court fees, your lordship. And they all are the of Calcutta State Transport Corporation, your lordship. Now the issue
Yes.
Now the issue is there, while sanctioning the pensionable gratuity, the dearness allowance is to be included in the pensionable gratuity or not. If my lord will kindly come to annexure P11 at page 30. This is a memorandum issued by the state government. Your lordship kindly see page number 30 P11. From the Joint Secretary to the Government of West Bengal to the Managing Director, Calcutta State Transport Corporation. With reference to above, I am directed to inform you that while calculating the amount of death retirement gratuity, the monthly emoluments shall include basic pay and deed. This is the government memorandum. Your lordship, they all are retirees of 2024, your lordship. The other STUs like NBSTCs, CTC, they all are getting their DNS allowance while calculating the pensionable gratuity. Only the CSTC retirees are not getting it. So
Gratuity is paid by the state government or the
That is all.
CSTC.
Or I'm deeply obliged, your lordship, whatever I was submitting, my lord, kindly takes this page 11, P11 once more. The same page.
There are three components. First
That's
is
right.
provident fund, then gratuity and pension. Though it is not pensionable.
It's pensionable gratuity because they are all covered under the GPA. So all are getting pension.
So only gratuity and provident fund and pension.
That's right.
So provident fund and pension is paid by CSTC
Lordship.
and the gratuity is paid by the state government on
Yes.
the basis of requisition sent by
Yes.
the.
Lordship.
Now, my lord,
Authority.
vis-a-vis this, my lord, kindly takes this page once more. My lord, kindly sees the reference. P11, my lord, which my reference. Letter such and such date 19th April 2022. Now, my lord, this is the letter, I've got a copy of it, which was sent by us, CSTC, to the government. My lord, lordship has looked at indicating the background and then asking them that you clarify, because kindly clarify that whether, my lord, this component will be included in us or not, so that because we have pressure from the retiring employees for this. My lord, this is the letter.
And why you are standing in the way if it is paid by the state
No, I tell
government?
you, lordship, we wrote to the government that kindly clarify. Vis-a-vis this clarification has come.
Yes.
Now, my lord, the problem, I have no issues. The problem, kindly says, my lord, speaking to my learned friend, kindly says last paragraph. This says concurrence of the finance department dated such and such. Now, my lord, only difficulty is this, that this payment, whether this should be from the date of this finance department's memorandum of 2025, or it should have a retrospective effect. Now, this has to be clarified by the government, if your lordship. Other than that, everything is fine. Whatever it
Whether
is,
it is to be given effect to from 4th September 2025 or from the date of retirement
that is
of
all.
the respective
That
employees.
is all. That is why my lord has pointed out this is the position.
But now you are calculating gratuity and sending requisition based on basic pay only,
Yes.
not the DNS allowance. But in other organizations, all the.
But I have
DNS
also
allowance is-
requested that since this is a welfare thing, that in the other organization, what is happening, what is the date of
And,
this?
Mr. Bihani, it is not paid by CSTC. It is not paid by your.
So that is why the letter. My lord, kindly visualizes this. Now, if I today realize, release this without the approval, my lord, tomorrow I'll be hauled up saying how you have done this. My lord, so for this, I have to take the approval of the state government.
Lordship, may I submit one thing, Your Lordship?
So let my learned senior friend come back, my lord, to the instruction. Lord, she will decide. Whatever from the date it has to pay, we will pay it. আর কি সাবমিট করিস না বাবা, অনেক করেছি, তুই শান্ত হয়ে বস,
তারা সবাই পাচ্ছে।
বেশ করছে, বেরিয়ে যা না ঘর থেকে, ও তাহলে থাক। এই আপনি না ওরা মামলাটা ওর নাম দেবে। তুই এক কাজ কর, ওর কাছে গিয়ে আর্গুমেন্ট। ये लेटर यहाँ रखी हुई पर
You have sought for clarification that what is the meaning of monthly emoluments.
also, my lord, in the first
They
paragraph,
have already clarified it.
Clarified saying that the monthly emolument should include basic pay and pay and DA
Yes.
with reference to this finance department.
Yes.
So, my lord, the only thing is it's a one minute thing. My lord, let them clarify that this is the position, you get it from this. I'll release it.
Really, you obtain instruction.
Written here, Lordship, calculating the amount of their retirement gratuity, the monthly emolument shall include
With reference,
pay and D.
with reference to this memo. So, what is the cutoff date?
Or Lordship may direct the concerned department to inform the corporation.
Lordship,
उसे सुन क्यों रहा है उसके बाद सुन क्यों रहा है দেখুন মামলা গুলো অর্ডার আছে
my lord, may I submit one thing, Your
সে
Lordship?
কাজ করছে
Date or retirement gratuity.
Lordship.
Monthly emolument shall include basic pay and DNS. No further clarification is needed, required.
No, I tell your lordship, subject to your lordship
Language
pleasure.
is very much clear.
Clarification is not at all.
Monthly MLO means
I tell your lordship, clarification.
calculating the amount of date and return, and the state is not objecting to that.
No, I tell your lordship, the clarification is not at all required whether this component will be included or not.
No, no, from which date? It is from the date of retirement.
If your lordship wants, it's like,
Yes, date and
if the
retirement.
state is
gratuity.
happy with that, I have no issues.
That is from the date following the date of death, or retirement from the date following the date of retirement.
So lordship is holding that there is no cutoff date as far as retrospectivity is concerned. That is the problem. Supposing today, a gentleman has retired in the 80s or 90s, and gentleman retires today, so he will also be. That is the clarification I needed.
It's all right.
The petition. But that
Affidavit of file or affidavit of service. Affidavit of service filed on behalf of the petitioners is taken on record. Next paragraph.
Your lordship, that
Issue relates to
department to inform the
calculation of gratuity. Either calculation of gratuity on death or retirement of employees of Calcutta State Corporation.
Calcutta State Transport.
State Transport Corporation.
So you have respondent 3 Calcutta State Corporation. Calcutta State Transport Corporation. Yes, Calcutta State Transport Corporation.
Correction করে দিন।
Stop. According to the petitioners, based on clarification provided by the Joint Secretary to the Government of West Bengal Transport Department, dated 4th September 2025, gratuity which is payable on death or retirement of the petitioner, retirement of employees, death or retirement of employees of CSTC. Includes basic pay, and DNS allowance. Stop. Next paragraph. Now, stop. It is prayed on behalf of the petitioners that appropriate direction may be given upon the concerned respondent authorities to consolidate gratuity of the petitioners, including DNS allowance component.
DNS and basic pay also.
Basic pay has already been taken care of. DNS allowance component. As at present, as at present, PSTC is calculating gratuity based on basic pay only. Next paragraph, Mr. Bihani, learned senior advocate representing CSTC, has submitted that though a clarification is provided with a memo dated 4th September 2025 on behalf of Transport Department in response to a letter of CSTC dated 19th April 2022, but it is not clarified in the said memo whether consolidation of gratuity consolidation of gratuity by including DNS allowance component is to be made from the respective dates of retirement/death of employees, or from the date of issuance of such clarificatory memo dated 4th September 2025. Next paragraph. State respondents are represented by learned advocate, who is directed to file learned advocate. Stop. Have you made joint secretary party?
Secretary was made a party, but
Why joint secretary has not been made party?
leave may be kindly granted to me, so I will.
Joint secretary, next paragraph. Joint secretary, Government of West Bengal Transport Department is directed to file a report in the form of affidavit disclosing whether effect of clarification as contained in memo dated 4th of September 2025 is to be granted from the date of retirement / death of the employee or from the date of said memo. Stop. Let such report be filed by fortnight from date. Stop. List the matter under the same heading for further consideration on 22nd December 2025. Next paragraph, leave is granted to the learned advocate representing the petitioners to amend the cost title and add Joint Secretary to the Government of West Bengal Transport Department as additional respondent in course of this day. Stop. However, service of notice upon additional respondents stands against it since state respondents are represented by London. উপরে যেখানে ক্যালকাটা স্টেট ট্রান্সপোর্ট কর্পোরেশন করেছি উইদিন ব্র্যাকেট ফর শর্ট সিএসটিসি করতে
Deep level issue.
Only one thing, Your Lordship. The person was retiring in 2025. Post April 2025, they are getting their DNS allowance also.
I have no difficulties. The
Retirement,
moment it is said, I'll release it.
very well.
Deep level issue. My lord, next bunch of matters, my lord, Lord has
Item-
passed an order. Can my junior be here, my lord, with the usual order?
Interest.
This is the more or less the usual orders. If I can, my lord. I'm sorry.
CSTC matter.
Yes.
Yes.
My junior.
Salary millet calculated on 180 days millet. Instead thereof millet, I am entitled to millet 300 days millet. Similar order had been passed millet by a coordinate bench also. I have annexed that also millet.
Yes, please call the matter. Let the matter be considered.
Item number
Yes,
3,
millet.
page 19 is the coordinate bench order.
May I file the
You are
affidavit
appearing
of
for state.
Only one matter. Item number
This matter you are appearing for the state.
millet? May I millet statement millet take your lordship to millet the coordinate benches order millet. Page 27 millet.
Is West Bengal State Transport Corporation or
No,
West
millet,
Bengal
millet,
Transport Corporation?
CSTC, Calcutta State Transport Corporation.
But West Bengal Transport Corporation is made party.
Millet, I'll tell you lordship.
Then
West
Calcutta
Bengal
State
Transport Corporation is the millet. Under that nomenclature millet, other state transport units are millet
Yes,
there.
yes. What is your case?
Millet, I retired in 2024 millet.
When you retired?
I retired millet on millet 31st of March 2024 millet. Your lordship will find that millet.
Very well. 31st of March 2024.
Millet.
You
Thereafter,
retired on
millet?
31st of
Yes,
March 2024. Then
Initially millet,
what you are praying for?
millet,
Enhancement of leave salary.
yes millet. What was
At the time of releasing retirement dues, on what basis leave salary was paid to you?
180 days. Millet kindly comes to
So
millet
you
page
are
21.
praying for leave salary
On
considering
millet 300 days.
300 days,
Calculated on
not 180 days.
millet.
What is the basis of your claim?
I'll millet kindly then millet comes to page 23 millet. This is a transport department letter millet to the managing director CSTC millet. Page 24.
Page 24.
Yes, page 23 millet. I'm so sorry millet. Page 23. Subject is millet. Annexure P4 millet. Revision of pay and allowances for employees millet. Page 25 millet kindly comes to millet bottom. Millet, this is relevant millet. Page 25 millet bottom. Relevant millet.
Which clause? 5 or 6?
9 millet.
9.
Benefit of leave encashment millet bottom. Page 25 bottom millet.
Page 24A.
Page 25 bottom millet.
Yes.
May I read millet? The payment of encashment of unutilized leave, the recommendations of the pay commission shall be accepted. The employees of the corporation will receive
Will
committed
encashment.
encashment of leave up to 300 days, subject to the condition that the expenditure towards such encashment of leave encashment benefit will have to be borne by the organization itself. The benefit to the encashment will be admissible to those who will retire on or after 1/4/2008. Millet. On similar issue, millet, writ petition
So
was
this benefit was up to 300 days.
millet.
Now this was will retire this the benefit
Managing
to
director millet.
encashment will be the benefit to the encashment will be admissible to those who retired or will retire on or after 1st of April 2008.
Millet.
In the present case, petitioner retired on 31st of March 2024. So therefore petitioner is
My lord,
entitled.
similar matter.
But it is said up to 300 days.
Yes, my lord. I am only
Not
claiming
300 days.
not 300 days. 300
2
days.
means 300 or below 300.
If let kindly, my lord, that next annexure, my lord, similar matter, my lord.
Yes.
My lord, passed by your Honorable Justice Aniruddha Roy, my lord.
Yes. Yes.
My lord, page 28 of that order, my lord, bottom paragraph, my lord. Page 28.
Just a minute.
28 last paragraph.
28
Just a minute.
last paragraph.
Just a minute.
Last paragraph.
Just a minute, please.
I'm so sorry.
So the first part is relating to interest.
Yes, my lord.
That you are not paying.
No,
for.
no, 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 no. That I have received for regarding Millard.
Interest you have received.
Yes, Millard. Provident fund also I had
Yes.
earlier Millard.
Yes, I get you. Just
there Millard.
in addition to
Second part.
who is respondent number 5 to consider your
Millard,
representation.
managing director. Millard. His order I have annexed Millard. Page 31.
Managing director.
Yes, Millard. He gave a hearing Millard. Page 31 Millard is the order.
So let the managing director be directed to consider.
He had allowed
representation.
300.
Where is your representation?
Millard, next page Millard. 32.
25th August 2025.
My lord.
Have you made managing director party?
Yes, Millard. Managing director is
Calcutta State Transport Corporation, who is representing?
Mr. Bihani. Representation through the learned advocate.
managing director is Millard 5.
Please.
Where will he make a representation?
Yes, Millard.
By fortnight, and he will decide the same in accordance with law within 6 weeks thereafter.
Very well.
Issue. Already this has been allowed
My lord.
in case of other employees
Other employees, Millard. Yes.
on consideration of representation
My
in terms of the order passed by the coordinator.
my.
So why you are not releasing the same? If it is allowed in
All
case
the
of
other STUs Millard are given 300 days Millard. Only Millard CSTC is
Yes.
giving Millard 180 days Millard.
in case of others, when it is allowed, then why direction for consideration of representation?
মামলাগুলো তো হচ্ছে সেই জন্য।
I think there are some
It is a standard format. Let's say CSTC Millard only 180 days Millard. Let it be calculated if it is 250
Affidavit
days.
of
it's
service
so be-
filed on behalf of the petitioner is taken on. No, next file. Petitioner was employee of Calcutta State Transport Corporation, within bracket for short corporation, who retired on superannuation on 31st March 2024. Stop. Petitioner has prayed for consolidation of leave salary or petitioner has prayed for consolidation of leave encashment benefits. From 180 days to 300 days.
Right.
Consolidation of leave encashment benefits based on calculation of 300 days, not 180 days, in terms of memo dated 17 in terms of clause 9, Roman capital 9, clause 9 of memo dated 17 September 2009 issued by the Joint Secretary to the Government of West Bengal, Transport Department. Next paragraph. Corporation and state respondents are represented by learned advocates. Next paragraph. Since it is pointed out by the learned advocate representing the petitioner that prayer is already made to the managing director of the corporation, being respondent number 5, for enhancement of leave encashment benefits, this court finds such prayer needs to be considered by the said respondent number 5. Next paragraph. Petitioner is granted leave to make a representation seeking enhancement of leave encashment benefits by fortnight from date to the respondent number 5. Stop. If such representation is made within the aforesaid time, respondent number 5 shall take decision in accordance with law by 6 weeks thereafter, and same shall be communicated to the petitioner by 7 days thereafter. Stop. In the event decision is taken to enhance benefits of to enhance leave encashment benefits, consequential steps shall be taken by the concerned respondent authorities for releasing the same for releasing same to the petitioner. Writ petition stands disposed of urgently.
I'm grateful.
If he is otherwise eligible.
Yes.
Next matter.
Item number 4. Similar prayer millet, similar matter millet. He
What
retired.
eligibility? He has already retired. All other benefits are given. What further eligibility you require? Tell me.
180 days to 300 days up to, I'm just expressing.
That would be.
Otherwise eligible.
Yes.
What other eligibility you are referring to?
If he is entitled to get up to 300 days.
That is the purport of this order. When retired?
Millet retired on Millet, 8th of
8 of the month.
8th
Generally, that
of
it does not
February
happen.
2023.
Where you have stated.
Paragraph 3. Millet, 31st of January 2023.
Cannot be 8.
31st of January 2023. Sorry, Millet. That is not the thing. So sorry, Millet. 31st of January 2023.
So no. Respondent number 5 is the managing director.
Yes, Millet. In all the writ petitions, Millet, respondent number 5
Same
is the
order হবে, শুধু date of retirement 31st of January 2023. Disposed of.
Item number 5. Millet. Next matter, Millet, retired on 31st of July 2023, Millet.
Right. 31st July, where you have stated.
Paragraph 3, Millet.
Date of retirement 31st of July 2023, same order.
Item number 6. He retired on Millet 30th of September 2023.
30th September 2023, same order.
Coming late in item number 5,
5, state. Yes, give your evidence.
minus from court number 17 I'm coming.
Yes.
Obliged to Lordship.
Item number 7. My lord, he retired on 31st of October 2018. 31st of October.
October 2018. Same order.
Item number 8. He retired on March 31, 2024.
31st March
31st
2024.
March 2024.
Same order. Give your appearances.
Item number 9. Let the petitioner retired on 31st July 2024.
Thirty-first July
2024 31st July 2024. Paragraph 3
শোনো, কোথাও হি থাকলে এটা সি হবে, ফিমেল ক্যান্ডিডেট। Disposed of.
I'm grateful. Item number 10.
I am the respondent, Union Appeal. Lord, may I be permitted to file this appearance? Lord, there is a private respondent. It appears to me, Lord, that the private respondent has not been properly served. I think so.
For this starting matter.
You are appearing for the petitioner.
I'm appealing for the
Well,
petition.
this matter relates to railway service
Lord,
and railway pension.
there
This
is
matter will
a
go to
problem.
the Central Administrative Tribunal. Your Lordship has no jurisdiction.
Lord, I was also, Lord, in a disturbed mind, Lord, that the matter should go before the tribunal,
Tribunal.
Central
Yes,
Administrative Tribunal. Wrongly,
The
it had-
petitioner is working where?
Lord, he is working as a Lord, at Asansol.
Where? In which department?
Railway
Railways.
Engineering Department. He has been given the provisional pension. Provisional pension he has already been given. But the thing is, Lord, that his other just a minute,
Which railway?
Eastern Railway, Lord. But Lordship, assume
Affidavit of service filed on behalf of the. Now you are praying for pensionary benefits.
Lord, I'm preparing for Lord, the retirement benefit. Provisional pension has been paid. But all the retirement benefits have been held for the reason, Lord, there was an inquiry and I have been exonerated in that inquiry. Inquiry was duly constituted.
Affidavit of service filed on behalf of the petitioner is taken on record. Stop. Petitioner was an employee of Eastern Railway.
Yes.
Who retired on superannuation.
On 31st,
And has prayed for release of retirement
benefits.
Stop. Since petitioner was an employee of Eastern Railway, writ petition at this stage is not maintainable before this court.
My Lord.
Is Railway Authority, you are representing Railway?
Yes.
Railway Authority is represented by learned. Next one. Writ petition stands dismissed as the same is not maintainable. Stop. However, this
No,
order,
for lack of jurisdiction, Lordship
however,
kindly.
this order shall not preclude the petitioner to approach Central Administrative Tribunal on the self-same cause of action.
Much obliged.
Parties to act on the
Much obliged.
server copy.
But this question was itching me, my lord. So when I went through it, my lord, it was filed by junior. This.
Item number 11.
It's a line
Yes.
that matter is the line is appearing for the respondents in 11, 12 and 13. I'm praying for short possible, my lord.
Not today. Not today. Mr. Kundu, come back. Not today. Pass over.
Passover?
Not pass over. Not today.
Not. My lord,
That high.
yes, hi. My lord, 69.5 and above. Yesterday, your lordship's pass an order. It has not been yet server, my lord. I can, if it
I have
it has been
signed
server, I shall.
Nothing is left. I have signed all the orders. Now it is to be, it will be on the server by in course of this day.
I shall produce the order tomorrow. When the matter.
Item number 12.
12 is also same, my lord. 12 and 13.
Not today. Not today. Item number 12, not today. Call.
Item number 13.
Where is Mr. Lahiri?
13 is
Other matter is coming.
The same order is to be passed,
Yes,
permitting the petitioner to
to-
very well obtain the order from the server and place it before this court. I will
yes,
consider it.
That's much.
12,
12 and
not today. 13,
13 also same.
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 Not today. Not today.
Much. Leave you.
Item number 14.
Mr. Kundu, try to find out. I am telling both of you that the point which was raised by this court in connection with rule clause 2D,
Yes.
that it will be rounded up to the next higher centimeter.
Next has
So there is no scope for lowering the
there is
height.
yes.
So whether this aspect was considered by the division bench of Madhya Pradesh High Court,
More, that has
which was relied upon Mr. Lahiri during course of hearing.
yes, that has the Tushar Singh has not relied. I have gone through
Go
that
through
judgment.
those judgments and find it out whether it has been relied upon or not.
Yes. Much obliged.
This file. Yes.
My lord, kindly see, my lord, page 112. What happened, my lord? The father and uncle of the petitioner, my lord, gave up their land. My lord, there was a scheme, my lord, for my lord giving employment in lieu of my lord the land taken by the ECL, land in the land losers.
Land loser category.
Yes, yes. Now, my lord, that has been rejected by the impugned order. Now, my lord,
Where is the order?
yes, that is page 112.
12.
It's a longish order. Ultimate conclusion, if your lordship kindly sees.
Yes, conclusion, page
Page 113.
113.
Kindly see, my lord. On the middle, my lord, the definition of owner is given. We are kindly see, my lord, apart from the above query on the middle,
Yes.
just above one.
Yes.
Apart from the above query, on a query,
Apart from above, on a query.
on a query, Sri Chetan Sharma, Additional Solicitor General of India, stated that at the outset, I avert to CNM Act 1973. The Act confers right, title, and interest of the owners in relation to coal mines of the to the central government from the appointed day, that is 1st of May 1973. Therefore, on the appointed day, the right, title, and interest of all the erstwhile owners of the coal mine standards transferred to the central government free from all encumbrances. While the Act elaborately defines mines under Section 2H of the Act, however, for definition of the owner, one must take assistance of the Mines Act 1952 in accordance with Section 2N and Section 2O of the Act. Section 2.1 of the Mines Act 1952 defines owner as follows. Then the owner has been defined. Then we kindly see 2. Next paragraph. The Mines Act separately recognizes immediate proprietor, lessee, and occupier as the owner of the mine. As per the aforesaid definition, in order to establish ownership over the mine, one need to have documentary proof as to when a mere occupier of the mine can claim over it. The Honorable Supreme Court, in the manner of Bharat Coking Coal versus such and such, reported in such and such, emphasized the definition of the owner as follows. Then will kindly see 3. Further, the section 3B of the Act clarifies that any lessee operative prior to or on the appointed date shall stand terminated once the operation of section 3 of the Act takes off. Section 3B is reproduced below. Then will kindly see, in view of the above, considering the facts and figures and legal opinion of such and such and such and such, to HOD legal HQ ECL HOD stated the since on the same subject matter, opinion of 2 advocates have been obtained. Opinion of such and such may be relied as it is more elaborative and it has been rendered by court level. As such, the employment file is returned back from the. This is Milord. Now, what they say, Milord, if your Lordship would kind enough to come to page 112.
You have got the compensation. Now you want a job.
That was the scheme.
Now, where is the scope for interim order?
No, interim order, there is no scope, but Milord, this order, Milord, has to go, Milord, on the face of it. Kindly see, Milord, 112, last paragraph of 112. Kindly see, however, during scrutiny, Milord, the competent authority is scrutinizing my case. A lease deed void for number 4895 dated 12 June 1959 has been found, which was executed between Ashutosh Adhikari, that is my predecessor, the son of Nandan and Mohanlal Goenka, son of Porimal Goenka. It is mentioned that the deed, said deed, the lessor, that is Ashutosh Adhikari, son of Sachidananda area, by an agreement dated 10th February 55, agreed to grant mining lease of 999 years for all the seams, vein, stratas of coal and coal mining rights and relative surface rights in and under the said plot number 261, along with other plots in Komadai Mauja to the lesser Mohanlal Goenka, son of late such and such, at a royalty on raising after deducting colliery and boiler consumption on all rupee 1 anna per ton. Well, this is their case. Well, what they say, when my predecessor transferred the land to Coal India, their predecessor had executed a 999 years lease to these Goenkas, and as such, my predecessor did not have title on the date of transfer. But this cannot be. Kindly see, Milord, the deed. Kindly see, Milord, the one of such deeds, Milord. Kindly see page 67. রেকর্ডটা কত পাতা?
So it was a lease for 999 years in respect of 999 years in respect of plot number 261, and which was executed in favor of one Porimal Goenka.
Yes, they say
so this was not executed in favor of Coal India or any coal company.
No.
Then from Porimal Goenka this land was taken.
No. That is the whole difficulty. Kindly see, Milord, one of the
if it is a factual issue, Mr. Bhattacharya, not an affidavit is necessary.
Definitely. I'll kindly see page 67 once. I'll clear
at
that
stage at the threshold, because you are saying no. If it is a lease in favor of one Porimal Goenka, And
Then my
ultimately,
predecessor could not have
your right
transferred it.
goes. Then your right goes for 99 years. 999
9
years.
years, permanent.
999 years. And now you are saying, no, this is not the situation because you are to be considered as owner in respect of plot number 261. And coal company took the land directly from you. If this is the situation, then you have a right. But if ultimately if it is found that no, land was not taken from the petitioner but from one Ashutosh Porimal Goenka, then you have no case.
Yes.
Then you have no case. So this needs to be decided on exchange of evidence. It's a
Definitely.
factual issue involved.
Definitely. But only one thing, my lord, if your lordship.
No further thing to do. File your affidavit of service.
On the last occasion, my lord.
You filed it. Matter is heard in presence of the learned advocates representing the petitioner, Coal India, Eastern Coalfields Limited, Eastern Coalfields Limited, and Union of India. Stop. Next paragraph. In the writ petition, challenge is laid against order dated 2nd February 2025, issued by HOD/LRE, Sonepur Bazari area ECL, whereby claim of the petitioner for appointment under land loser category was refused. Next paragraph. Though Mr. Bhattacharya, learned advocate representing the petitioner, has made arguments with a prayer to set aside the memo dated impugned order dated 2nd February 2025, but on perusal of the said impugned order dated 2nd February 2025, court finds due to involvement of factual issues, the legality and validity of said order dated 2nd February 2025 needs to be adjudicated on exchange of affidavits. Next paragraph. Let affidavit in opposition to this writ petition be filed by 1 week after ensuing Christmas vacation. An affidavit in reply thereto filed by 2 weeks thereafter. Next paragraph. Parties shall be at liberty, or petitioner shall be at liberty, to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging affidavits. কালকে ওটা খুব ভালো করেছে jurisdictional পয়েন্টের উপরে যে
Item number 15.
The petition in this matter, my lord.
The respondent, my lord, I pray some time, my lord, have just been briefed, my lord, some time for instructions. It's also a case,
Yes,
my lord,
Mr.
where
Ghosh.
Well, I am praying for the stay of the disciplinary proceedings during pendency of this.
When the charge sheet was proceeding was initiated.
Yes, all are, my lord, very recently. So,
When what is the date of
my lord,
date of issuance of charge sheet?
page 33,
111.
April 2025.
1 week, come back.
So, they have fixed the, my lord, on 11th, the next day. Let they not, my lord, lordships may, my lord, may not proceed.
Let me consider.
They will not, my lord. I will intimate them, my lord. Let them not.
Very
my
well.
lord, I will intimate.
Very well. Let he intimate, my
In
lord.
the previous matters also.
Time of call, learned advocate representing ECL,
my lord, all the response.
representing the representing Eastern Coalfields Limited, has prayed for accommodation to obtain instruction. Next paragraph. A petitioner is represented by learned advocate. Next paragraph. Hearing of this matter stands adjourned till 11th December 2025, when it will appear under the same.
But in the meantime, my lord, they may not, but on 11th they have fixed the inquiry.
If this court is satisfied that you have a case, court will pass an appropriate order.
Very well. Very well.
What will happen in one day inquiry?
My learned friend is, my lord, also assured, my lord.
Next.
Item number 16.
16, my lord, I am appealing for the petition.
My lord, there was a direction, my lord, that we need to inform the district judgeship of Paschim Bardhaman about the pendency of this matter. My lord, we have informed. My lord, the information, the instruction is yet to come from the legal cell, my lord. If your lordship may...
engaged.
Oh, then it's okay.
Mr. Bandyopadhyay.
District Judge Paschim Bardhaman.
My lord, here my impugn order, that is page 70.
That is a mutual transfer.
No, my lord, that
No,
is another
not that matter.
That matter is not. My lord, this is my gradation list has been deducted, my lord, from 2018 to
Just a minute, let me go
2022
through my
year.
own. Just a minute.
Yes.
September. Whether another related matter I have heard.
No, my lord.
Yes, why this in the gradation list, petitioner has been placed at the bottom of gradation list, considering this promotion on 10th August 2022.
Can you come to page 20?
Page 22.
Yes.
Yes.
The-
Now the petitioner, just a minute, name then the effective date 10th September 2018. Though the case is made out that petitioner was promoted on 10th September 2018. If you come to page
22.
22 is the list. Then page 79. Page 79, date of appointment as Group D, 10th September 2012. Date of appointment in the present post, 10th August 2022.
My lord, on 10th August 2022, he has joined the post, my lord.
Joined the which post?
Promotion post, my lord.
Then,
Yes, my lord.
then why in the list it is stated that effective date of promotion 10th of September 20?
Can you come to page 22, my lord? 22. Just the paragraph above the column, my lord.
Where is the list where it is stated that your date of promotion is 10th September, 10th August 2022?
10th August 22, I am not my lord promoted. I already promoted 2018. 10/9/2018.
Yes.
Date of.
But is there any document where from it that you are agreed by the preparation of gradation list where a wrong date is indicated?
Yes.
So where is such date?
My lord, that I made objection before the authority concerned after my lord, publishing the draft gradation list. That is objection page 57 onwards.
What is page 70?
Page 70, my lord, that is the first page, that by way of order this gradation list has been published.
Yes, that is what I am asking.
Page 70.
Page 70.
Yes.
Then where it is stated that your promotion is to be counted from 10th August 2022.
That is page 79. Page 79 is the my lord column.
Yes.
Serial number 2.
2.
Solil Roy. That is PS.
How this has been done?
Date of birth, date of appointment.
Yes. How this has been done?
Can you come to page 22, my lord?
20?
The
Yes, page 22.
paragraph just above the column, my lord. Starting as the promotional benefit, my lord. Got it?
Retrospective effect right from the date of vacancy against which income that's promoted.
This is only for the notional fixation of the pay, my lord.
Optional benefit shall have retrospective effect right from the
Incumbents promoted.
against which income that's promoted. Right from the date of against which income. Now, petitioner joined on 10th August 2022. So that's why in the gradation, can it be done?
No.
When the vacancy arose, notional benefit was given, actual benefit was not given. Actual benefit was given from 10th August 2022. So whether the promotion will be reckoned from 10th of August 2022 or from 10th September 2022.
He joined the post on 2022.
Maybe vacancy arose. Promotion was given from 10 with effect from 10th September 2018. Notional benefits given, but actual benefit, monetary benefit was extended in favor of the petitioner on and from 10th of August 2022. That does not obliterate petitioner's claim of promotion with effect from 10th September 2018. And while calculating future benefits as well as pension, you have to reckon this date of 10th of September 20. Yes, Mr. Banerjee, representing state High Court administration. How this can be done?
Well, may I hand over this statement of fact? Page 2, my lord, kindly. Page 2, point 12, page 2, point 12. Point 13 as well, madam.
Yes, from the in normal case, seniority is to be counted or reckoned from the date of joining. But when vacancy arose and petitioner's claim over such vacancy on promotion was acknowledged by granting notional benefits from the date of arising vacancy, then how the period during which notional benefit was extended in favor of the petitioner can be ignored?
No, they did not work at that period of time.
Issue. Matter is heard in presence of the learned advocates representing the petitioner, High Court administration, state respondents. Who is appearing for the state?
Mr. Bandyopadhyay, na?
And you are also representing District Judge Paschim Bardhaman, state respondents and District Judge Paschim Bardhaman. Stop. Issue relates to preparation of gradation list on 16 June 2025 by the District Judge Paschim Bardhaman, being respondent number 3. Stop. It is pointed out by the learned advocate representing the petitioner that though petitioner was appointed, that petitioner was appointed initially as Group D staff under District Judge Paschim Bardhaman or under Judge of Paschim Bardhaman on 10th September 2012. And subsequently he was promoted to the post of process server, VDE. Memo dated 15 June 2022.
Yes, that is annexer page 21.
Vide memo dated 15 June 2022 with retrospective effect from 10 September 2018. It is contended on behalf of the petitioner that while preparing gradation list on 16 June 2025 by the respondent number 3, date of joining of the petitioner in the promotional post on 10th August 2022 was taken into consideration and petitioner was placed accordingly in the gradation list. It is argued on behalf of the petitioner that if petitioner's promotion is reckoned on and from 10th September 2018, then name of the petitioner will feature at the appropriate position, at the higher position in the impugned gradation list. Stop. In this regard, reliance is placed on the memo dated 15th June 2022 issued by respondent number 3, wherein it is stipulated that the petitioner would get benefit of retrospective effect of promotion from the date when vacancy of process server arose. Stop. It was also spelled out in the memo dated 15 June 2022 that petitioner would get notional benefits from 10th September 2018 being the date when promotional vacancy in the promotional post arose. Though monetary benefits were allowed to the petitioner from 10th August 2022 being the date when petitioner actually joined the post. Next paragraph. State respondents and respondent number 3 are represented by learned advocate who has made an attempt to defend the gradation list prepared on 6 June 2025 based on facts that petitioner joined the promotional post on 10th August 2022. Therefore, seniority of the petitioner as process server needs to be reckoned from 10th August 2022, not from 10th September 2018. Stop. High Court administration is represented by learned advocate. Next paragraph. Having considered the respective submissions made on behalf of the parties and taking note of the memo dated 15 June 2022 issued by the respondent number 3, it is apparent that right of the petitioner to be promoted to the post of process server was acknowledged by the respondent number 3 with effect from 10th September 2018 in view of availability of vacancy from the said date. Stop. However, promotion was, however, effect of, however, such order was issued on 5th, was issued by the respondent number 3 on 15th June 2022, was issued by the respondent number 3 with a memo dated 15 June 2022, as a result whereof petitioner could join the promotional post on 10th August 2022, not prior to that. It needs consideration that petitioner was granted notional benefits from 10th September 2018. Stop. Next paragraph. Therefore, for all practical purposes, petitioner's promotion to the post of process server needs to be reckoned from 10th September 2018 and not from 10th August 2022. Next paragraph. Hence, respondent number 3 is directed to modify the gradation list which was prepared on 16 June 2025 and place the petitioner at the correct position, reckoning petitioner's promotion to the post of process server on 10th September 2018. Stop. Respondent number 3, next paragraph. Respondent number 3 is directed to complete the aforesaid exercise by 4 weeks from the date of communication of this order. Stop. Writ petition stands disposed of. Origin direction.
My lord, all consequential benefit.
I have not recorded your submission.
My lord, all consequential benefit, my lord, kindly, my lord, because the
ওখানে আমি করে দাও exercise by 4 weeks from the date of communication of this order, and petitioner shall be entitled to get all consequential benefits thereafter. हाँ.
Item number 17.
For last occasion, my learned senior friend will raise a question of maintainability of this writ petition since an appeal provision is there. Now, your lordship's query was
POS Act.
Yes.
So I have heard the one petition, and there are two other persons file this writ petition. Yes, yes.
But that the distinction is the other employee has retired. That's the
Whose writ petition was heard by this court.
Yes. And the lordship has given directions with certain.
Yes, yes. This is two other employees.
Who are still in service.
Yes.
About in this present case, my lord, we have been there is recommendation, threefold recommendation against us. One is disciplinary proceeding, and another is, my lord, compensation, and another is reflection of this punishment or procedure in our service book. My lord, two that has already been implemented.
First, address me on the point of maintainability in view of availability of appeal provision. As you apprehend that other side will take the point of
on last
maintainability.
occasion, my lord already
Yes.
raised this issue. But if your lordship stands to section 18 of this act, section 18 says, my lord, any person aggrieved from the recommendation made under subsection 2 of the section
18, just a minute.
180.
Yes.
Any person aggrieved from the recommendations made under subsection 2 of section 13 or under clause I of clause I of subsection 3 of section 13 or subsection 1 of subsection 2 of section 14 or section 17 or non-implementation of such recommendation may prefer an appeal to the court or tribunal in accordance with the provisions of service rules applicable to the said persons, or where no such service rule exists, then without prejudice to the provisions contained in any other law for the time being in force, the person aggrieved may prefer an appeal in such manner as may be prescribed. And next, the appeal under subsection 1 shall be preferred within a period of 90 days from the recommendation.
So why you are not preferring appeal?
Now, I will kindly have a look to this, our rule.
May prefer an appeal to the court or tribunal.
But I have kindly, I have folded the page, it's rule 27 of our Calcutta High Court rules, my lord. My service rule. Calcutta High Court.
1996. Yes. Now, in the service rules, is there any provision for
Yes,
preferring
I
appeal?
have handed over. Set 21, I'm sorry. 20. I'm sorry. Right. But I have folded the page, my lord.
Yes, page.
I have folded page 23.
Yes.
Rule 21 appeals. Where any penalty is imposed by the registrar, appellate or side or original side, an appeal shall lie from his order to the Chief Justice, but no appeal shall lie from an order of the Chief Justice made either under this rule or so and so.
Yes.
Now, there was the provisions, rule section 18 says, before a court or tribunal. Section 18 of that particular act.
Court or tribunal. There is a court or tribunal. So, do you mean to, do you mean to say that if in the service rules there is a provision to prefer an appeal only to the court and tribunal, in that event or
if any
in that
tribunal-
event appeal can be preferred, not otherwise?
It's an appellate authority. Rule 21, it's an appellate authority, and neither it can be termed as tribunal nor as a court. And section 18 is very clear. It says
No
before a
such
court or
service rules
tribunal.
exist without prejudice to the provisions
That created a problem for me.
But what about the second part of this appeal provision, last part, where no such service rules exist, then without prejudice to the provisions contained in other law for the timing in force, person aggrieved may prefer an appeal in such manner as may be prescribed.
That prescription comes under, my lord,
Yes,
rule.
After the word court or tribunal, the lordship will find there is a sentence called in accordance with the following service rules applicable. Yes. So Lord, the sentence doesn't stop at court or tribunal. It says in accordance with the provisions of the service rules applicable.
court or tribunal in accordance with.
So therefore,
Now, the next portion is, my lord, the prescribed. And prescription that comes under, my lord, rule.
Prefer an appeal, come back.
Before whom? But
In
kindly hear me for 5 minutes.
In terms of 21.
Kindly hear me for 5 minutes because we are in a difficulty. Otherwise, I would not, my lord. This is the rule 2013 rules, my lord. There is also prescription for filing of this appeal. Rule 11.
To the provisions of section 18. That is rules relating to 2013 Act.
Yes, ma'am.
This was section 30. Then you are relying upon rule 11 appeal.
Rule 11 appeal.
Yes.
It says, my lord, subject to the provisions of section 18, any person aggrieved from the recommendation made up the subsection 2 of section 13 or so and so, so and so, so and so, implementation of such recommendation may prefer an appeal to the appellate authority notified under clause A of section 2 of the Industrial Employment Standing Orders Act so and so. Now, two authorities are there. One is, if we go by 21 of our...
That is in the act itself.
Kindly clarify that situation, because now UGC, under UGC there is a appeal provision under subsection 8, clause 8 and 5. But why I am before Lordship? In case of college, UGC prescribed a rule under 8.5. Following that, there was in earlier direction that appeal is to be preferred there. Now, when writ petition is moved before this Honorable High Court, now the coordinate bench says no, that should be before the appellate authority under Rule 13. Well, I am handing over. Rule 30, 2013 rules, following Rule 11, an appeal should be live before the authority under this Rule 13, not before the UGC authority. So now, challenging that an appeal is pending. Now, I am really...
That pertains to UGC authority.
UGC authority,
but
college
here,
authority.
When in terms of section 21, when the appeal provision is there, yes, and there is in the service rules there is an appellate authority. So you prefer an appeal before the Chief
Even
Justice?
in UGC, my lord, there was an appellate authority. 8.5 UGC, my lord, they recognize an appellate authority, prefer an appeal before them. That was challenged before this court. If your lordships go by the coordinate bench judgment, what I have handed over. But there it says no, you have to prefer appeal before the appellate authority under this Rule 2013. Now the appellate authority, they filed an appeal before the division bench and say we cannot be. Now, this is my situation. I'm in a helpless condition.
Appellate authority says?
They says no, we cannot be the appellate authority. UGC is the appellate authority since under the UGC rules. Yes, that's their appeal. Appeal is pending. Appeal is pending.
That is in connection with University Grants Commission.
Yes. In case of college. High Court ni bolchi na sir. High Court ni bolchi na. Now, whether I have...
So far, University Grants Commission is concerned, there is a separate rules.
Yes.
Relating to 2013. But that rule is not applicable in case of High Court employees.
And that rule specify 8.5, there is the appellate authority.
Court is not considering that rule.
Then kindly clarify.
Now I remember that in case of professors and UGC colleges affiliated to UGC, there is a separate rules altogether.
Yes. 8.5 that has been mentioned there. And that says there is an appellate authority. But the single bench says no, you have to go before the 2013
Regulation 2G of UGC regulation was considered 2015.
Sir, may I just take 2 minutes?
Yes.
Section 18 once again.
Section 18.
15.1 has 2 parts.
Just a minute. Yes, section 18.
18 has 2 parts. 18.1. First part says any person agreed from recommendations, etc.
It's a recommendation under section 13.
13.3.
13.3.
13. Or non-implementation of such recommendation, this is by the victim, may prefer an appeal to the court or tribunal in accordance with the provisions of the service rules applicable to the said person. Then look, the second part starts with the word or.
Just a minute. May prefer an appeal to the court or tribunal, it says.
In accordance with the provisions of the service rules. So look, when service rule is mentioned after the court or the tribunal, it really specifies to the authority prescribed under the service. Then kindly come to the next part, which is disjunctive with the sentence or. Where no such service rules exist.
Yes.
Then, without prejudice to the provisions contained in any other law for the titling in force, the person aggrieved may prefer an appeal in such manner as may be prescribed.
Then this regulation comes into play.
And this prescription is in the rule. This prescription, the rule that my learned friend read, talks about a situation where there is no service rule.
But in the instant case, there is a service rule relating to preferring an appeal. So question of giving effect to or consideration of these rules under Act of 2013 does not arise.
Absolutely doesn't.
But kindly then record that I have to prefer an appeal in terms of 21 before the Chief Justice. I will be fine. I will be fine. And one thing I will be praying before Lordship, because rule section 18 subsection 2, it gives me only 90 days time.
So therefore, Mr. Kaur, your submission is very specific that on the strength of section 18 read with
Rule 21.
21.
Yes.
Read with 21, appeal should be preferred before the Chief Justice.
Correct. Because Lord, following the recommendation, already Lord Registrar has passed an order, Lord, implementing the recommendation. And Lord, that order is also impugned in this writ petition, which is at page 250.
Yes.
And Lord, the service rule says that from the order of the registrar,
Appeal lies.
page 258, second column.
So this is the order by the registrar for implementation of the recommendation.
It's already implemented. Now, Lord, my legislature will have to take steps against this order. If he actually the recommendation has merged into this order of the registrar.
But in other case, why this point of
Because he is not employment employee.
oh, he has retired from service. Yes, yes, yes. That's why a direction was given for recovery.
I do not take the point. Appeal is not maintainable by. The ordering portion. D and E is relevant for our purpose. And I'm told that it is.
So since an order is there, so far registrar is concerned.
Yes.
So therefore, under 21, it's rule 21. The appeal should be preferred before the Chief Justice. And this is a recommendation in terms of 13.3.
And against that also, one of the appeal is before the Chief Justice.
Yes.
But against this implementation, Chief Justice, even in the case of my lord, against this recommendation, I have to.
Already, yes, already recommendation was considered by the Registrar General, and Registrar has passed an order, which is under challenge. Against this, we prefer an appeal.
This
I need to challenge the recommendation also, because which is the foundation of this my lord particular
recommendation is transformed into an order of the registrar
without granting any opportunity of hearing this implementation. We are concerned about D, E, and F. Sir. If about reflection.
Matter is heard in presence of the learned advocates representing the petitioner and High Court administration. Stop. Where is the recommendation of pause?
Recommendation, my lord.
Page 257 is the concluding part. Is
224. Starts from 224.
Okay. In the writ petition, challenge has been thrown to the recommendation dated 26th August 2025 of the Committee for Prevention of Sexual Harassment of Women at Office/Workplace in the High Court, Calcutta, whereby certain observations and directions were given against the petitioner, wherein certain observations and directions were given against the petitioner. Petitioners, there are two petitioners. Petitioners are primarily aggrieved by.
I have also challenged the punishment order.
By the said recommendation, agreed by the said recommendation dated 26th August 2025. Stop. During course of hearing, Mr. Kaur, learned senior advocate representing High Court administration, has pointed out that after the recommendation was issued, ওইটা the state committee করে দেবে. after the recommendation was issued by the said committee on 26th August 2025, taking note of the same, Registrar General High Court Calcutta has passed an order dated 16 September 2025 for implementation of the recommendation. Stop. Learned advocate representing the petitioner submits that the recommendation submits that the order dated 16 September 2025 of the Registrar General is also under challenge. Stop. Next paragraph. It is submitted on behalf of the petitioner. Though there is an appeal provision under section 18 of the sexual harassment of women at workplace within bracket prevention, prohibition and redressal, close bracket Act 2013, but same does not apply in the present case. As a result whereof petitioners approach this court with the present writ petition. In inter alia, questioning a recommendation dated 26th August 2025 and order of the Registrar General
16th September.
Dated
16th September.
16th September 2025. According to the petitioner, Section 18 within bracket 1 of the said Act said Act of 2013 confers right upon the affected party to prefer an appeal in the event relevant service rule governing the service of the affected party contemplates preferring appeal to the court and tribunal. Court or tribunal. Court or tribunal. Stop. Now, court or tribunal, but here in the instant case, Rule 21 of the High Court Services Rules 1960 hereinafter referred to as the said rules of 1960, close bracket, though provides for preferring an appeal against the order of the registrar, appellate side or ordinal side, but there is no provision to prefer appeal against the court, prefer appeal before the court or tribunal. Stop. Next paragraph. In order to refute such submission, learned senior advocate representing High Court administration has also relied upon Section 18 of the said Act of 2013 vis-a-vis Regulation 21 of the said Rule 21 of the said rules of 1960. Stop. It is emphasized on behalf of the respondents that it is provided under Section 18 within bracket 1 that the appeal can be preferred to the court or tribunal in accordance with the provisions of the service rules applicable to the affected person Stop. As per section 20, as per rule 21 of the said rules of 1960, which governs the service of the petitioners, provides appeal which can be preferred before the Honorable Chief Justice against the order of the Registrar General. It is contended on behalf of the respondents, since service rules applicable in case of petitioners contemplates appeal under Rule 21, same needs to be pressed into service. As a result whereof, at this stage, appeal needs to be preferred before the Honorable Chief Justice. In terms of Rule 21. Next paragraph. In consideration of the respective submissions made on behalf of the parties and taking note of the relevant provisions of the said Act of 2013 and said rules of 1960, court finds that as a recommendation was made by the said committee in terms of section 13 within bracket 3 of the said Act of 2013, and there is existence of appeal provision in the relevant service rules applicable to the petitioners, appeal needs to be preferred before the Chief Justice, before the Honorable Chief Justice / Acting Chief Justice in terms of Rule 21 of the said rules of 1960. Yes. Though a feeble attempt is made on behalf of the petitioners based on Rule 11 of the sexual harassment of women at workplace within bracket prevention, prohibition and redressal, close bracket rules 2013, in order to point out that there is an appeal provision to the appellate authority notified under clause A with small a of section 2 of the Industrial Employment within bracket Standing Orders close bracket Act 1946. But such argument does not come in aid of the petitioners, as it is found in section 18 of the said Act of 2013, that there is specific provision to prefer appeal before the appellate authority in terms of service rules applicable to the affected party. Next paragraph. In aforesaid conspectus and taking note of availability of alternative efficacious speedy remedy, किसे लिस्ट बोलना से At this stage, writ petition is found to be, at this stage, writ petition is not entertained and same stands dismissed. However, this order shall not preclude the petitioner to prefer appeal challenging order of the Registrar General dated
16th of September.
16 September 2025,
As well as recommendation, my lord, kindly.
16 September 2025, wherein directions were given to give effect to the recommendation of the said committee dated 26th August 2025 before the Chief Justice / Acting Chief Justice or is sentence একবার পড়ো to give effect to the recommendations now before the appellate authority in terms of rule
21.
In terms of rule 21 of the said rules of 1960.
But I will be facing another more difficulty because section 18 subsection 2 says
These
it.
rules may be called the Collector High Court Service Rules Conduction of Service. এই রুলটাকে প্রথমে পুরো বলে দেবে 1960. Stop. Urgent Xerox certificate.
I will be facing one difficulty. But section 18 subsection 2 says that should be within 90 days. And that 90 days, my lord, crossed the month of November. 26th August was the day of recommendation, though that was communicated to us on 20th of September by the order of this.
But when you have filed the writ petition,
or prior to
within 90 days.
Within 90 days.
Within 90 days. Where is the provision that to prefer appeal within 90 days?
Section 18 subsection 2.
Yes. Yes. Since petitioner shall also be at leave to file an application seeking condonation of delay, and this court expects that the same shall be same to be taken into consideration while same shall be taken into consideration in accordance with law, keeping in view of the fact that writ petition was filed on 19 November 2025, August, September, October, November, 26th August,
26th
August, September, October, November. Keeping in view of the fact, কি বললাম? Which is prior to expiry of 90 days from the date of issuing recommendation on 26th August 2025 by the said committee.
Extremely good.
Yes. After short break, this fixed matter at 12 will be taken up. এটা রাখো। Yes.
Yes.
All the fixed matter.
Item number 30.
Lordship, I beg to appear on behalf of the Public Service Commission.
But I need to show certain things before Lordship. Yesterday, Lordship considered.
Yesterday.
I'm sorry, day before yesterday. I'm sorry, day before yesterday. Last occasion, page 45. Your Lordship kindly comes to page 45 for once.
Yes.
My lord, the language is specific. It's an indicative advertisement and not an advertisement itself. One. Secondly, it says the commission will hold. It's a mere proposal. It's a mere proposal to hold a recruitment process. Next, it says detailed information regarding commencement. My lord, it's very important, this word, commencement. Detailed information regarding commencement and closing date for online applications, age limit, such and such. So syllabus of the examination, etc., will be available in the commission's website. So this is a mere proposal to hold.
Detailed information. Detailed information. Detailed information regarding commencement and closing date for online applications, age, limit, qualifications.
Qualification. Yeah, exactly.
Scale up pay fees through online and offline scheme and syllabus of the examination will be available.
So my lord,
in the commission's website.
So my lord, the qualification parts remains undefined here. The qualification will be given later on.
Applying for the post, candidate are registered themselves through the same website. Those who have the same website. Whether previous enrollment was made, it says that those who have already made enrollment through the same website, so and so earlier, also need to register afresh.
Possibly on earlier occasion, some that is, my lord, not subject matter of this petition, but
yes, Miss Sengupta, come to page 45.
Lordship, I've seen the page 45.
Indicative advertisement dated 28 December 2023, where the last line, second paragraph, last line says that those who have already made enrollment through the same website earlier also need to register afresh. Whether previous enrollment was made for participating in 2023 judicial examination.
That information I do not have, Lordship.
My lord,
Lordship, I would
kindly,
like
may I
to
just-
show your Lordship, generally the detailed advertisement are the continuation of the indicative examination, and PSC follows in all the examination the same process.
No, problem is here the Supreme Court judgment.
Yes, but Supreme Court has specifically said, Lordship.
Yes, let us
if
come
I
to
may-
the judgment, All India
yes,
Judges Association.
Yes, kindly see page 89 or
Paragraph-
paragraph 89 of the judgment, Lordship.
Yes. Please let us consider paragraph 89 jointly. Paragraph 89.
I would like to place
relevant subparagraphs are 7.
No, Lordship. First, I would like to place.
Please have patience.
9.
Please have patience. Read from page subparagraph 7. Place it. All the high courts, please place it, Ms. Sengupta. Place it, read it.
All the high courts and state governments in the country shall amend the relevant service rules to
amend the relevant service rules. Yes.
To the effect that the candidates desirous of appearing in the examination for the post of civil judge junior division must have practiced for a minimum period of 3 years to be eligible for the said examination. To fulfill the said requirement, the rules shall mandate that the candidate produce a certificate to that effect duly certified either by principal judicial officer of that court or by an advocate of that court having a minimum standing of 10 years duly endorsed by the principal judicial officer of such a district or a principal judicial officer at such a station. Insofar as the candidates who are practicing before the high courts or this court, they shall be certified by an advocate who has minimum standing of 10 years duly endorsed by an officer designated by that high court or this court. We further direct that the experience of the candidates which they have gained while working as law clerks with any of the judges or judicial officers in the country should also be considered while calculating their total number of years of practice. The rules shall also mandate that the candidates who are appointed to the post of Civil Judge Junior Division pursuant to their selection through the examination must compulsorily undergo at least 1 year of training before the presiding in a court. Next clause, it is desirous that the number of years of practice completed by a candidate desirous of appearing in the examination for the post of Civil Judge Junior Division be calculated from the date of their provisional enrollment or registration with the concerned State Bar Council. Lordship, the next point which I would like to place, it is further directed that the said recruitment of minimum years of practice shall not be applicable in cases where the concerned High Court has already initiated the selection process for the post of Civil Judge Junior Division prior to the date of this judgment and shall be applicable only from the next recruitment process.
Yes.
Lordship, here I want to submit, Lordship.
Subparagraph 9.
9, Lordship.
Yes.
The Judicial Department has indicated the numbers of vacancies, and by indicating the numbers of vacancies, they have already started the selection process, initiated the selection process, because for any advertisement, the process of selection starts from the receipt of receiving the numbers of vacancies. So they have indicated prior to this judgment, and the indicative advertisement has been published prior to this judgment. And in the detailed advertisement also, that has been, if your Lordship remembers, before the division bench, when the court directed, they have immediately published the advertisement. And in the age clause, if I may place before your Lordship, kindly see advertisement 23, which starts as
Yes.
Lordship, kindly see advertisement 23, which is at page 29 of the writ petition.
Page 23.
29. This is
The writ petition.
Yes. This is the advertisement number 19 of 23. Why I am showing that indicative is the part of the detailed
Page.
Page 29.
29.
Now, Lordship, kindly see page 30, the age clause. Page 30,
the age. Yes.
Not less than 23 years and not more than 35 years on the date of advertisement for the examination on 28/12/2023. That is the date of the indicative examination.
Advertisement.
Sorry, date of the indicative advertisement. So they were aware that the indicative examination, it is a continuation of the indicative examination. And Lordship, just
When
because
the High Court has forwarded the names to the Public Service Commission through state government, when not names, the number of vacancies.
With regard to the 2023 recruitment, the vacancy list was forwarded on 19th of October 2023.
19th
Before the judgment.
October 2023.
And with regard to the
Just a minute. Vacancies on 19 in respect of 2023 and in respect of 2024.
March 2025.
5th March 2025. Yes, carry on.
Yes, and this judgment has been published.
Now, this 19th October 2023, it was forwarded. And when it was received by the Commission, Public Service Commission?
That date.
That you have to obtain instruction.
Yes, Lordship, and my instruction is
Just then the indicative advertisement was issued on 28 November.
It is at page 45, Lordship.
That is after this.
After receiving the numbers of vacancies.
Vacancies were
Yes,
forwarded to the
yes. Indicative examinations, indicative advertisements, page 45 and 46, Lordship will find in the writ petition. And immediately after this judgment has been published, Lordship,
Yes.
the Public Service Commission has send the Lordship, I will place a memo dated 18th August 25 along with the revised draft.
So according to you, Ms. Sengupta, cut-off date is 28th December 2023. As indicated against the age clause.
Yes. And in the both advertisement, in the age clause, the
And
date
that is
is
the date of
mentioned.
indicative advertisement.
Yes, yes. And they were aware. If they had any problem, they could have come because they have applied.
No,
Pursuant
no,
to
we
this,
have applied. I have not applied.
Lordship, may I place these two papers?
Yes. And in terms of Malik Mazhar Sultan, there is a time schedule within which it has to be completed.
They have followed and published the indicative. It is only due to this OBC issue, this delay was made. Lordship.
And there is a stay order.
Yes, Lordship.
I authored one judgment and Justice
Ivana Hussain. Ivana Hussain.
That is
Ivana Hussain's judgment.
There was a delay and I immediately undertaking to publish the advertisement, and immediately that day advertisement was published 23 and 24 regarding 24.
Ivana Hussain.
I have the judgment.
Yes.
If your Lordship wants.
So that's why the entire process was stalled.
Yes, Lordship.
Then the judgment was delivered in the month of September 2020.
Yes, Lordship.
2025. Yes.
And immediately when we have noticed that the Supreme Court judgment has come, we have intimated the judicial
Whether that
department.
judgment was appealed against?
No, Lordship.
No.
That judgment,
No.
Ivana Hussain?
No.
No, not appealed. Now, what you are trying to address this court?
Lordship, my submission is this 25 judgment is not applicable for the
No,
23
these
and
documents, why you have
why I am placing this judgment, that commission is aware that this judgment has been passed, and for that commission has already forwarded the redrafted recruitment rules to the judicial department. Now what is required to be done, the notification will be forwarded to the commission. This is the process I have taken instruction. After this, the draft notification will be forwarded to the commission for its views. Either commission will agree or give some suggestion, and finally the judicial department will issue the final notification recruitment, including the qualification criteria. Lordship will find in the revised draft they have already done it.
No, Public Service Commission has forwarded a letter dated 18th August 2025 to the Principal Secretary, Judicial Department.
Along with this revised draft.
Along with a draft copy of this final advertisement.
Yes.
Final notification for recruitment.
This is for the 25 examination. Even the 25 indicative has published for the detailed examination. Recruitment rules must required to be revised, putting the clause of 3 years of experience and all. Lordship will find in the revised. If your Lordship see the revised draft, number 3, qualification for recruitment.
Number 3, yes, qualification, yes.
Number D, clause D, an enrollment advocate having maximum 3 years practicing experience.
Now, whether this has been this has been given effect to this draft rules.
Lordship, that we have not received anything further. This is the latest instruction I have received. Now the judicial department will be able to enlighten, Lordship.
Judgment from
Yes. And Lordship.
Just a minute. So this requires amendment of recruitment rule.
Yes, Lordship.
Otherwise, this cannot be given effect to.
Lordship. For the 25 examination, Lordship.
Straightway, this qualification cannot be inserted in the advertisement without backed by amendment.
Yes, Lordship.
Now, High Court has passed an order in one writ petition, which was in connection with Andaman and Nicobar Islands. That has been referred to in paragraph 3 of the letter of the Public Service Commission dated 18th August 2025. It is also pertinent to mention here that pursuant to the judgment passed by the Honorable High Court in connection with WPA so-and-so, the department is requested to amend the existing rules for an exam center in Port Blair. That is in connection with different issue or same issue.
Same issue, Lordship. It will all will be applicable for 25 examination, because in paragraph 7 of the judgment also it is written that all high courts have to amend the service recruitment rules, Lordship. And Lordship, they are challenging in this writ petition page number 47.
Yeah, challenge this.
Yes. What further you are submitting?
Lordship, they are challenging the page 47, 23rd 8 2025 important announcement. This is nothing in the advertisement. In the clause age, the date was written at indicative. They have just clarified. If anybody has any clarification is required, that is why they have clarified. I do not find any merit in this writ petition that commission has violated any constitutional provision. Or
the steps steps have been taken to incorporate the directions of the Supreme Court by way of amendment.
Yes, Lordship.
By way of amendment of the rules, and for which a Public Service Commission has sent a letter.
And the revised
amended rules are already there.
Yes, Lordship.
Whether it has been finalized and notified, draft amended rules.
That High Court will be.
Forwarded to the judicial.
Yes, Judicial Department.
Yes.
The State Board.
Has been followed. But you ask for the rules from the judicial department.
Now, when you will initiate the selection process of 2025 judicial service?
The indicative has been published. The final has not yet published.
Indicative has already been published.
25 indicative has been published.
When?
Lordship, I'm giving the date. 22nd November 25.
2025.
25. That is why the PSC has forwarded all this re-revised, so that in the main advertisement, they can put all those clauses and all.
Yes, what is your submission, Mr. Banerjee?
With regard to commencement of
No, what is your submission relating to amendment of rules? Because unless until rules are amended, this cannot be the order, the judgment of the Honorable Supreme Court cannot be given effect to.
Honorable Supreme Court will have to amend or bring out the rules.
Now, prior to what is your stand with regard to 2023-2024? Make it clear.
With regard to 2023 and 2024, my lord, we have indicated the vacancies on 27th of June 2023.
2023.
2023.
High Court forwarded the vacancy 19th October 2023 in connection of 2023 and in 2024 5th March 2025.
Both of these dates are revised vacancies. First vacancy
Very well, final vacancies forwarded. That is prior to the delivery of judgment. Judgment came in, was delivered on 20th May 2025. Yes. So what is the stand of High Court? Whether the straightway it can be incorporated in the advertisement or amendment of rule is required.
But if I name the hand of
So that I want from High Court. That I want from High Court, that what is the stand?
specific instruction like this.
The examination is fixed on 7th.
Yes, all arrangements have been done.
Yes.
In 7 centers, the examination have taken instruction. In Darjeeling and Kolkata, in 7 centers, everything has been done.
The last one, which is called has to be taken in such a whatever thing that from High Court, you lost
What is the present rule, Ms. Sengupta? Show me the rule.
Rule I'm not carrying, Lordship, but as per if we see the advertisement,
You have the rule.
difficult to tell you because the amendments are next one after the other.
In 2023.
কিন্তু রিডিভাইজারের মধ্যে অ্যামেন্ড করে পাঠিয়েছে।
(1959) rules. Now, I want to know from both of you that in order to incorporate the provisions in terms of the judgment of the Supreme Court dated 20th May 2025, whether this amendment is necessary or not, or straightway in the advertisement it can be included.
Whether this application of just to be guided by law. In Article 34, India says, since it is one of the junior division, it says appointments of persons other than district judges official service of a state shall be made by the governor of the state in accordance with rules made by him, in accordance with the rules made by him in that behalf after consultation with the State Public Service Commission and with the High Court.
234 you are referring to.
34. Just start from 233 to 248 books.
Great. So rules are necessary. If it is not backed by rules, in that event there will be other spate of litigations that there is no such rule, but it has been incorporated. 234 read with 309.
And in any event, Lordship, the qualification is more than the required qualification what was there earlier. So in any event, they will be not prejudice. This is I am making from the bar letter submission. প্যাকেট জায়গা 3 হয় বেশি তো আচ্ছা 0 থেকে 3 হয়ে যাচ্ছে আরো তো ভালো কোয়ালিফাইড বেশি থাকলে ভালো এক্সাম দেবে আচ্ছা
Yes. And 7 date. Hmm.
Yes. So therefore, rules are necessary.
Once to paragraph 89, paragraph 7, at the same time, if in this environment normalize the fact that there will be ongoing recruitment rules, recruitment and academic will also take place. So the guidance in line follows that where the concerned high court has already initiated the selection process, this will not apply. Now in that sentence, we have to find the point down.
Subparagraph 9.
Page 62.
So 7 says amend the rules. Of course, the Supreme Court knew that it is not to be done in a matter of 3 or days in fact. So
That's why High Court was directed.
High Court has been said in paragraph
9.
Generally,
High Court has already initiated in cases where concerned High Court has already initiated the selection process for the post of Civil Judge Junior Division prior to the date of judgment and shall be applicable only from the next record. So that initiation process is by forwarding the vacancies.
Yes.
That's why I have taken the dates from the High Court and when the vacancies were forwarded. Yes.
May I, my lord?
Not at this stage is required. Let me see.
My lord, what my learned friends have submitted, that can be refuted. Those are not acceptable, my lord. Why, I tell you, lordship? Paragraph 9 of the judgment, the main issue is initiation. It is further directed that the said requirement of minimum years of practice shall not be applicable in case where the concerned High Court has already initiated. The word is the initiation of the process. Now, my lord,
the procedure is that initiation so far High Court is concerned is only for forwarding vacancies. Nothing
my
else.
respectful submission, that is not the initiation. How it is
How
initiated,
High Court will initiate otherwise?
no, that is
Only identifying the vacancy, general SC, ST, and tentative vacancies and clear vacancies, and this will be forwarded to the judicial department, and that is the
right.
duty of the High Court,
Right.
responsibility of the High Court.
My lord, initiation.
That's why Supreme Court has very consciously included
That's what I'm saying.
directed at the High Court to
So
initiate.
going by that, my lord, the first paragraph, all the high courts and the state governments in the country shall amend the relevant service rules. High courts do not amend the rules. It is the legislature who amends the rules. So my respectful submission is that High Court has been used as a generic word because under which the whole recruitment process is conducted. First paragraph says, paragraph 7, all the high courts and the state governments in the country shall amend the relevant service rules. High Court never amends any rules. It is the statute, the legislative bodies, those who amend the rules. Therefore, High Court, Supreme Court was cautious. Supreme Court ought not to have mentioned the word High Court for amendment of the rules. Only the state authorities. I'm coming.
Yes.
I'm coming, my lord. Now, my lord, kindly take page 47. What was the need of page 47, if I may pose this question to myself? Is if everything is very clear, no infirmities,
page 47.
47. That amounts to changing the rule of the game after the recruitment notification was initiated. It was not required.
How this can be issued without a regular rules?
I'm coming to your lordship. I'm coming to your lordship. With this, I have the answers. My lord, this answer, when it is initiated, has clearly been stated. For kindly take for once. Clearly been stated when last page, page 42, paragraph 42. Clearly been stated in Tej Prakash Pathak 7 judges bench. Recruitment process commences. That is initiation. Commences from the issuance of the advertisement calling for applications and ends with filling up of vacancies. This is 7 judges bench observation. My lord, I cannot stay away from this. The initiation has to be from the publication of the result.
What is the purport of Tej Prakash Pathak judgment?
Sorry, I failed to understand.
What is the purport of the Tej Prakash Pathak's judgment?
Tej Prakash Pathak.
Whether the rule of game can be changed in the midst or not?
Yes, I'm coming to that. First point, kindly take paragraph 42.1. Recruitment process, this is the conclusions part.
Yes.
First point. The Honorable Supreme Court settles it. Recruitment process commences from the issuance of the advertisement calling for applications and ends with the filling up of vacancies. So the commencement part, initiation from the date of issuance of the notification. 2, eligibility criteria for being placed in the select list notified at the...
Here the situation is different. Since subparagraph 9 says High Court to initiate, so far this state is concerned, High Court initiation of selection process by High Court is
requisition.
Only to forward the names, forward the number of vacancies and the nature of vacancies. Nothing else.
That is not the initiation. My lord, initiation happens from the date of...
More than that, High Court cannot do anything.
Exactly, that's what I'm saying. Initiation commences from...
You develop your case, but today I'm not going to...
No, kindly allow me to make my submission, my lord.
I have considered it, but I'm not going to stall.
My lord, I need to refute this. Your lordship heard them extensively. I
have heard you.
I deserve a chance to show. I have the other that
Last
says.
date also I have heard you.
My lord, I need to refute their contentions.
Today dismissing the
very well. Do not kindly hear me first, my lord. They have made their extensive submission. Kindly allow me to refute that. I deserve a chance to refute, my lord. Your lordship may not accept my submission, but kindly allow me.
No, today court is considering to pass an interim order.
After hearing me, my lord.
I have heard you. So for interim order, I am not dismissing the writ petition today.
Not saying, my lord.
I will direct them to obtain instruction, but I am not going to stall the examination.
Very well. Very well. After today.
And moreover, you had the qualification to apply. You have not
I understand everything. After they have submitted, came up with the new documents, which is not available with me. I need to.
So therefore, very well. If necessary, there will be an exchange of pleadings.
Absolutely.
So that you can deal with those.
Hear me first, my lord. Kindly, my lord. Kindly do not make up your lordship's mind before
hearing.
It's
question of not making up. I have heard you extensively in absence of in presence of other parties, excluding public service.
Not on their points.
The matter is fixed only for consideration of the submission on behalf of public.
Absolutely not on their points. I did not get a chance to refute their points today, which your lordship is considering today. Kindly allows me to make my submission at least. I did not get the opportunity to controvert their points here.
In the writ petition, in the writ petition,
for 2024, kindly consider my prayer for stay. If not 2023, that has not been proceeded yet.
advertisement dated 13th August 2025 issued by the Public Service Commission, West Bengal, within bracket hereinafter referred to as commission, close bracket, is questioned, which was issued for conducting West Bengal Judicial Service Examination 2024.
23-24.
Stop.
না শুনলে আর কি করবো বল, মানে শুনবেই না যখন, তার জন্য আর কি লাভ আছে, তো রেডি হয়ে আসার মানেই নেই কোনো।
Such advertisement, the number of such advertisement is 9 of 2024.
Page 23. 29. 19 of 23. Page
9 of
20.
2024 for 2024 selection
Yes,
process.
yes.
Stop. Sentence একবার বলো তো। 2023 code. Stop. Advertisement is 19/2023. Stop. A similar advertisement was also published on August 2025, being number 9/2024, for conducting West Bengal Judicial Service Examination 2024. Stop. Next paragraph. Petitioner is one of the eligible candidates who could offer his candidature for his participation in the aforesaid examinations of 2023 and 2024, pursuant to both the advertisements dated 13th August 2025. Stop. আগে দিতে দেখো তো 13th August বললাম, 2024 বলেছি। 13th August 2020, 13th August 2025. Stop. However, it is submitted by Mr. Lahiri, learned advocate, representing the petitioner, that he chose not to offer candidature since directions as contained in the judgment dated since direction as contained in paragraph 89 of the judgment dated 20 May 2025 of the Honorable Supreme Court, passed in writ petition within bracket C number 1022 of 1989 within bracket All India Judges Association and others versus Union of India and others, were not complied with while issuing aforesaid two advertisements dated 13th August 2025 for conducting examinations of 2023 and 2024. Inviting notice of this court to subparagraph within bracket small Roman 7, small Roman 8, and Roman 9 under paragraph 89 of the under paragraph 89 of All India Judges Association Supra. It is submitted that now it is contended that respondent authorities were required to incorporate relevant provisions under the eligibility criteria, relevant provisions in the relevant provisions under eligibility criteria as contained in the aforesaid two advertisements dated 13th August 2025. Requiring desiring candidate, requiring desirous candidate must have practiced for a period of minimum period of 3 years for the post of civil judge within bracket junior division. Bereft of such eligibility criteria as prescribed in subparagraph 7 and 8 under paragraph 89 of All India Judges Supra. Aforesaid two advertisements dated 13th August 2025 cannot survive, as those advertisements were issued after delivery of judgment in All India Judges Association Supra on 20 May 2025. Prayer is made not to permit the respondent authorities to hold preliminary examination in connection with West Bengal Judicial Service Examination 2023, which is scheduled on 7 December 2025. Stop. This court has heard learned advocates representing West Bengal Public Service Commission or West Bengal Public Service Commission, state respondents and High Court administration. Stop. It is pointed out on behalf of the respondent authorities that as per subparagraph 9 of paragraph 89 of All India Judges Association Supra, কি বললাম সেন্টেন্সটা বলো। Requirement of minimum years of practice is not applicable in cases where concerned High Court, in cases where High Court concerned High Court has initiated. High Court has already initiated the selection process for the post of civil judge within bracket junior division prior to date of this judgment and shall be applicable only from the and such requirements shall apply from the next recruitment process. Next paragraph. On behalf of commission, again na hearing after referred to as commission bola ache dekho. On behalf of commission, it is contended. Now, on behalf of commission, it is contended to kede dao. On behalf of commission, it is apprised that indicative advertisement was published for holding West Bengal Judicial Service Examination 2023 and 2024 on 28
December
on
2023
28 December 2023
and
7 December 2024.
7 December. Yes, Lordship.
7 December 2024.
Sorry to interrupt, Lordship. And these indicative detailed advertisement are the continuation of the indicative advertisement and extant.
No. That is not. The advertisement is for 2023. Advertisement is dated 28 December 2023, and for 2024 examination advertisement date is 7 December 2024.
Yes, Lordship. Indicative.
কি বলছিলাম? Now, West Bengal Judicial Service Examination 20 West Bengal Judicial Service Examination 2023 on 28 December 2023, and such indicative advertisement for West Bengal Judicial Service Examination 2024 was published on 7th December 2024 and 7 December 2024 semicolon. Therefore, initiation of selection process needs to be considered prior to date of delivery of judgment by the Honorable Supreme Court in All India Judges Association Supra. Next paragraph. It is pointed out by the learned advocate representing High Court administration that as per rules identifying nature of vacancies, same were forwarded in connection with 2023 examination to the concerned authority of the state government on 19th October 2023 and for 2024 examination on 5th March 2025. Next paragraph. Therefore, it is submitted jointly on behalf of the respondents that initiation of selection process relating to both the examinations of 2023 and 2024 needs to be reckoned from a date from respective dates prior to the date of judgment, that is 20th May 2025, delivered in All India Judges Association Supra. Next paragraph. It is also pointed out on behalf of the Commission that steps are being taken to finalize new rules, which is called West Bengal Judicial Service within bracket recruitment close bracket rules 2025, in order to give effect to the directions of the Honorable Supreme Court as contained in All India Judges Association Supra. And in this regard, a letter was forwarded on behalf of the Commission dated 18th August 2025 to the Principal Secretary to the Government of West Bengal, Judicial Department. Stop. Draft copy of the West Bengal Judicial Service within bracket recruitment close bracket rules 2025, and the letter dated
Lordship can include this date also. There is one more letter.
And the letter dated 18th August 2025 are placed before this court and same are taken on record. Next paragraph. In order to appreciate the issue raised in this petition, in order to কি বলছিলাম raised in this writ petition, this court finds it apt to quote paragraphs 7, 8, and 9 under paragraph 89 of the judgment of All India Judges Association Supra. দেখো এইখান থেকে কোট করে দেব। Next paragraph. On conjoint reading of these three paragraphs, one thing is clear, that after delivery of judgment on 20 May 2025, respondent authorities or concerned authorities are required to incorporate relevant provisions which would require a candidate to apply for the post of civil judge junior division within bracket junior division sub jagay korbe, having practiced for a minimum period of 3 years. Stop. Question arises that when this requirement relating to eligibility criteria of the candidate for participation in judicial judicial examination needs to be incorporated in the advertisement issued by the authorities for conducting such examination. Next paragraph. Today, court is considering interim order. Court is considering prayer for interim order in order to stall preliminary examination in connection with West Bengal Judicial Service Examination 2023, which is scheduled on 7th December 2025. Stop. Next paragraph, prima facie it appears that the Honorable Supreme Court in subparagraph 9 of paragraph 89 of All India Judges Association, All India Judges Association Supra, directed the concerned High Court, All India Judges Association Supra directed the requirement of having practiced more than 3 years in connection with participation of a candidate in the examination shall not be applicable in case where concerned High Court has already initiated the selection process for the post of civil judge within bracket junior division prior to the date of this judgment, and shall be applicable only from the next recruitment process. Shall be applicable only from the next recruitment process. Stop. From the submissions made on behalf of High Court administration, it appears that identifying nature and number of vacancies for West Bengal Judicial Service Examination 2023 and 2024. Requisitions were sent on 19th October 2023 and 5th March 2025 respectively, which is prior to the judgment delivered by the Supreme Court in All India Judges Association Supra on 20 May 2025. Stop. Moreover, indicative advertisements were also issued on 28 December 2023 and 7th December 2024. Stop. It is submitted on behalf of the Commission that all arrangements for conducting preliminary examination in connection with West Bengal Judicial Services Examination 2023 is complete, and it is scheduled on 7th December 2025. Next paragraph. In view of aforesaid, in aforesaid conspectus, court is not inclined to stay preliminary examination scheduled on 7 December 2025. Stop. Next paragraph. Respondents are directed to file affidavit in opposition to this writ petition by two weeks from the date of communication of this order, and affidavit in reply thereto can be filed by 24th December 2025. List the matter under the heading hearing in the monthly combined list of January 2026. Next paragraph. Selection to be made for the post of civil judge junior division. In connection with West Bengal Judicial Services Examination 2023 shall abide by the result of this writ petition.
2023 and 2024 also. I've challenged both here.
Yes, but the examination is scheduled so
Yes.
far
So
2023 is
if your lordship
concerned.
is not observing the abide by only if it is limited to 2023, then 2024 gets out of the clutch of this observation.
No, if ultimately the writ petition is not heard prior to advertisement published in connection with 2020, advertisement is published
Window
prior
is
to
closed.
prior to preliminary examination in connection with 2024 examination. In that event, you will make an appropriate application. Next paragraph. Leave is granted to the petitioner to make an appropriate application in connection with West Bengal Judicial Services Examination 2024 if situation so arises. Stop. একটা ওপরে ওই inclined এর আগে is not inclined to তার আগে একটা লাইন অ্যাড করো. Moreover, this court cannot brush aside the fact that petitioner is having eligibility criteria in terms of the advertisements dated 13th August 2025 to offer his candidature for consideration of his appointment for the post of civil judge junior division, but he chose not to apply in terms of the said advertisements dated 13th August 2025.
This is one information as per Supreme Court's order. There was a 3 months time given to the state to amend it. That 3 months have passed. Now, what is the viability of this? Now, it's a very important question. As per Supreme Court's order, 3 months time was given. They have not done anything. Amendment was to be carried out within 3 months. It has not been done. That means their stand does not stand today itself.
Very well, let it be considered. That's why I have said that this directed that this selection shall abide by the.
And 2024, your lordship granted me liberty. Yes, yes. Grateful to your lordship.
Grateful, my
May I
lord.
take back very
File your affidavit disclosing all relevant documents.
Lordship.
Very well.
And as well as the reply you will.
Very well, my lord. Grateful to your lordship. Much obliged.
Item number 18.
18, my lord, I am appearing.
Appearing for the coal company.
The father of the petitioner was an employee under the Eastern Coalfield Limited, my lord. During the service tenure, the father of the petitioner died on 31/5/1993. 31/5/1993. When your petitioner was at the age of 5 years.
Yes.
Now, the mother of the petitioner made an application praying for to release the service terminal benefits. That was released subsequently. Two daughters of the deceased employee. One is the eldest daughter who was subsequently married. Our second is the petitioner before your lordship. The petitioner is unmarried. Now, the mother of the petitioner made an application praying for employment at the time of attaining the age of 18 years of her younger daughter. 2012, before that, she made an application praying for employment for her younger daughter. That application has not yet been considered. Petitioner itself.
When this application was made?
Yes, my lord. Your lordship kindly come to the application, my lord, page 26.
Date of application?
25 and 26.
Please tell me the date.
Yes, my lord. Date is 11/6/2012.
Page?
Page 25, my lord. The mother of the petitioner, who subsequently died in the year 2020. The mother of the petitioner wrote a letter. I am placing the
page 25.
25. She wrote a letter stating that with due respect, I beg to inform you that earlier I have already nominated to my daughter Kumari Durga BP, my deceased husband, late Chandilal BP, UG loader of Moira Colliery, who died on Ato. However, as desired by you, I am submitting herewith following fresh documents required for employment as per provision of the NCWA. Authority have received, total documents were submitted.
Now it has not been considered.
Not. Next page, there is the petitioner also made an
Yes.
My lord, subject to correction, this petition is suffering from the defects of delay, laches, and acquiescence, my lord. Petitioner died 1993.
Petitioner died?
No, the father of the petitioner is my lord. I apologize. I stand corrected. My lord, the father of the writ petitioner died in 1993. That time the writ petitioner was aged below 5 years. Now they sustained until 2012. At the juncture 2012, they file an application that, my lord, here a point to be pressed. Service book says the nominee for this benefit is the wife, the spouse. Now, my learned friend is talking about live roster. Live roster. Live roster is what, my lord, may I explain? There is a provision in the scheme NCWA, my lord, that if it is a male child and time to time the age bar is changed, but this at this juncture 1993 when the employee died, NCWA 5 was effective. Now at that point of time,
Supreme Court has said subsequently that on the date of consideration of the application,
my lord,
the scheme which is applicable, that will be.
My lord, I'm deeply obliged, my lord. So NCWA 5. Now NCWA 5.
There are other judgments of the Supreme Court.
Yes. There are many, my lord. I would not bother.
Which one will come in favor of the petitioner? That I shall follow.
Yes. And 2012, after almost 20 years, they are coming after sustaining the period without explaining the delay.
No. Question is whether your scheme permits then.
Yes. I can come back to the scheme only.
If your scheme permits appointment on compassionate ground,
yes,
on attaining age of majority, then the scheme will be followed.
my lord.
In the scheme, there is a provision that if the dependent member is minor, then his name is to be enrolled in the live register and which will be considered on attaining age of majority.
My lord, may I say, kindly.
Just a minute.
9.5.0.
9.50.
My lord, the particular 9.5.0 clause 3.
It is a case of death not for due to mine accident.
No. But during the service tenure,
Kindly comes to clause 3. It applies to mine and
or
coal.
for other reasons. Just a
Yes,
minute.
it comes.
Just a minute, or for other reasons.
My lord.
But one has to be age of 12 years or more.
My lord. My lord, in this case, it is 15 years at that point of time.
my lord,
It is
I
15
was
years.
I was at the age of 5 years. When my father died.
5 says 15 years, not even 12.
But at the time of death of the father, you were 5 years.
Yes, 5 years.
It says that
I was under
and male dependent of the concerned worker is 12 years. Male dependent of the concerned worker is 12 years and above age. But admittedly, on the date at the time of death of the employee, your petitioner's age was below 12 years, and petitioner was not the male dependent member. So how this will apply in your case?
No, my lord. The petitioner was under the age of 5 years at the time of death of the.
So how
father.
then?
No, she was come to the under the provisions of the life roster. She will automatically come under life roster.
Cannot you read 9.5.0 subclause 3, Roman 3?
In case of death, either in mine accident or for other reason, or medical unfitness under clause 9.4.0, if no employment has been offered and the male dependent of the concerned worker is male dependent of the concerned worker is 12 years and above is
below 12 years, and if he is female,
I am not a male limited. Female is subsequently it has been stated.
Where it is stated?
Pardon me, my lord.
Please, it is his writ petition. Allow him to place this case. Please take your seat. I will hear you. Don't disturb this court in this fashion. Yes. Where is the provision for female dependent?
He will be kept on a live roster and would be provided employment commensurate with his skill and qualifications when he attaining the age of 18 years. During the period of male dependent is on live roster, the female dependent will be paid monetary compensation as per rates as per para 1 and 2 above. This will be effected from 1/1/2000. My lord,
where is the provision relating to female dependent's age on the date of death of the employee?
Yes.
Where?
Your lordship kindly come that 9.4. I'm placing my 9.4. Employment on a dependent of a worker who is
9.4.
9.4.
Yes.
The disablement of the worker concerned would arise from injury or diseases, be of a permanent nature resulting into loss of employment, and it would be so certified.
No, that will not apply in your case. It is a case of employment to one dependent of a worker who is permanently disabled in his place.
No, he was not disabled.
It is not a case of disablement. It is a case of death. So you are seeking employment due to death in harness. Now 9.5.0 will apply. In 9.5.0 under subclause 3, it is specifically provided that in case of male dependent member below the at the age of 12 or above, on the date at the time of death of the employee will be considered. But petitioner's age, first of all, petitioner is not the male dependent member, is a female, is a daughter of the, please, she is the daughter of the employee and her age was below 12 years. How your case can be considered on the anvil of this 3.9.5.0? Demonstrate this, I will pass an order.
First one is that 9.5. Provisions of employment, monetary compensation to female dependents of the workmen who dies while in service and who are declared medically unfit as per clause 9.4.0. Above would be regulated as under. In case of death due to mine accident, this is not a mine accident. In case of death, total permanent disability due to cause other than mine accident and medically unfitness under clause 9.5.0, if the female dependent is below at the age of 45 years, she will have the option either to accept the monetary compensation at the rate of 3,000 per month or employment.
And not to employment. And not
or
employment.
Or employment.
Which clause you are reading?
2, 9.5.02, subclause 2. Above 40.
Just a minute. Oh, so in case of female dependent, you are submitting that if she is below 45 years,
yes,
she has a right.
She has a right.
In case of female dependent, is below 45 years. Yes, what is your sub?
My lord, firstly, may I say, I apologize that I disturbed my lord.
Yes.
My lord, that clauses, those clauses which he is referring, that is NCWA 6, my lord. NCWA 5 says otherwise, just only about the
According
age bar.
to you, which NCWA is applicable?
5. I have brought it.
5.
May I submit?
When it was introduced?
This was introduced in 1991.
1991.
Yes.
At the time of consideration of petitioner's application,
yes,
which NCWA was prevalent?
My lord, no. The date of death shall be considered, not the application, my lord. Application can be made at the, my lord.
No.
My lord, application can be submitted 2023. The date of death shall prevail.
I'm giving the citation.
May I say one thing, my lord?
NC Santosh versus State of Karnataka 2027 SCC 617.
NC Santosh?
Yes.
Yes, my lord.
Paragraph 17.
Even if, my lord, if
yes, what even if?
No, my lord, kindly allows me. The age bar is different. NCWA 5 is 6. 5 says 15 years. 6 says 12 years. There is no difference. It is not a issue in this matter, my lord. My lord, what I am trying to say is this this particular provision which my learned friend referred, it is applicable to the major applicants. For minors, clause 3 which my lord referred, that will be applicable, my lord, for minors.
That is for male dependent.
No. If there is female dependent, there is no provision for a minor. There is not even a provision for minor.
Heading is this. If that is not an issue, that which rule, which scheme will apply, in that also employment and monetary compensation of female dependent.
Yes.
Now it says clause 2, in case of death, total permanent disablement due to cause other than mine accident and medical unfitness. In case of death, total permanent disablement due to cause other than mine accident and medical unfitness under clause 9.4.0, if the female dependent is below the age of 45.
Yes, but this is not applicable
Below the
to
age
minors.
of 45 years and years, she will have the option either to accept the monetary compensation of 3,000 per month or employment.
Yes, but my learned friend has stressed she was kept on live roster, which is in the case of male dependent. My lord, live roster comes for the minors, not for the majors.
Automatically, these provisions.
My lord, he is attracting
9.5.3
live roster.
Yes.
So in this case, there is no provision for a female dependent and a minor.
Live roster means, my lord,
Minors. My lord, I'm pressing the point minors, not an adult. I'm not talking about the female spouse of the ex-employee. My lord, I am placing about the minor child. There is no provision for a female minor child.
To be considered for appointment on compassionate
Yes,
ground.
and before that, before coming to the gender aspect, my lord, the age bar. The scheme does not permit, even if it was a male child.
But what is the difference in between national coal wage agreement 5 and 6?
My lord, only the age 12 and 15.
Oh, that has been changed to 15.
Yes.
It is not significant so far this case is.
Yes. It has to be a male child. And my lord, may I submit this particular agreement was signed by all of them, my lord.
Agreement nobody is questioning.
My lord. Now they are, after accepting this, they are challenging in the year 2025 that this does not apply. My lord, if it was a male child, his advocate would have sustained.
When you attend majority.
I was born in the year 1988.
You attend majority.
88. That means, my lord, 12 and 6.
No.
2006.
Father died in 1993. At the time of death, your age was 5 years. So therefore, you became major 5 years plus 7 years. It means in 2000.
2006.
No.
Yes.
Oh, 5 years.
Yes.
5 years means 5 years plus 8 years. It comes to 13 years. So 93 plus 13, 2006, 2005-6. Now, if it is 2005-6, why you have filed the writ petition in 2025?
No, man. Actually,
what?
After demise of my father, my mother made an application praying for him release the service terminal benefits. Subsequently, she made an application on behalf of his younger daughter to claim for employment. That application was made by the. I have already read.
When this application was made,
actually no, not 2012. That's why I'm facing this matter, my lord. However, as your lordship kindly come to the page 25.
There is no date. Page 25.
My lord, at the top left.
However, she as deserved by you.
Yes, top left.
As deserved by you. That means.
And the father died in 1990. What is the object of granting compassionate appointment?
My lord.
It is not a vested right.
No.
What is the object? Immediate financial assistance is to be provided.
If she become the majority,
yes, sure.
my lord, your lordship kindly. After attaining the age of majority, my lord, she's already absurd.
Matter is heard in presence of affidavit service filed on behalf of the petitioner is taken on record. Stop. Matter is heard in presence of the learned advocates representing the petitioner and Eastern Coalfields.
My lord.
And in Eastern Coalfields Limited. Stop. Next paragraph. By presenting this writ petition, petitioner has claimed appointment on compassionate ground based on relevant provisions as contained under clause 9.5.0 of National Coal Wage Agreement within bracket NCWA. Stop. It is submitted on behalf of the petitioner that her father died on 31st of May 1993, and thereafter mother of the petitioner received all retirement dues. Stop. Mother also died.
2020.
Mother also died in 2000 in the year 2000.
2020.
2020. Mother also died in 2020. Stop. Based on the provisions as contained in 9.5.0 within bracket small Roman 3 of NCWA, it is stated, it is submitted that the benefit which has been provided to male dependent member of the deceased, male dependent member of the family of the deceased employee, petitioner is required to be considered for appointment on compassionate ground. By enrolling her name in the live register.
Live roster.
Live roster. By enrolling her name in the live roster. Stop. Petitioner made an application, or it is mother of the petitioner made an application. Page 25. Mother of the petitioner made an application.
After attaining the age of
application on 11 June 2012 for providing employment under compassionate ground to her younger daughter, and same is not considered. Next paragraph. On behalf of Eastern Coalfields, on behalf of ECL, prayer of the petitioner is opposed based on 9.5.0 of NCWA, as it is provided under 9.5.0 within brackets Roman small 3 close bracket, that benefit of employment on compassionate ground is extended to the male dependent family member of the deceased employee in the event male member, said male member, is minor on the date of death of the employee. There is a provision to enroll the name of the male member on the live register till he attains majority, and thereafter, in accordance with law, claim of such male member can be considered for employment. However, such provision is absent in case of female dependent member of the family of the deceased employee.
Now, female dependent not says.
And it is provided
only one male dependent.
9.5.0 within bracket Roman small 2, that a female dependent member below the age of 45 years will have the option either to accept monetary compensation of rupees monetary compensation per month or employment. But there is no specific provision which makes a female dependent member of the family of the deceased to be considered for appointment if such female member is minor on the date of death of the employee. Next paragraph. This court finds substance in the submission made on behalf of ECL, as there is no provision which makes a female member of the family of deceased to be eligible for consideration of her appointment under compassionate ground in the event C is in the event C is minor on the date of death of employee and C is minor on the date of employee, comma, on attaining majority.
My lord.
Stop. It is right that appointment on compassionate ground is not a vested right, and same is governed by the relevant scheme. Stop. If scheme does not permit such appointment, court cannot exercise discretion to extend such benefit. Stop. Moreover, object of providing employment on compassionate ground is to tide over immediate financial financial crisis which other members of the family of the deceased may face due to untimely death of breadwinner, comma, but here in the instant case, employee died on 31st May 1993 and the present writ petition is filed on 20 November 2025 claiming appointment on compassionate ground. It needs to be recorded herein that petitioner became major in 2006. In 2006. It needs to be recorded that petitioner became major in 2005-2006. Therefore, at this stage, no relief can be granted. At this belated stage, no relief can be granted to the petitioner. Stop. Writ petition stands dismissed. Next.
Deeply obliged, my lord.
Petition.
Item number 19. My lord, last. My lord, petitioner before your lordship, my lord.
Yes.
My lord, last
Who is
occasion.
appearing for Union of India?
Yes. My lord.
Where is he? Well, not today.
My lord, what happened, my lord? My lord, last occasion, my learned friend pointed out that the advisory which is under challenge that has not been inadvertently annexed. My lord, to do a supplementary affidavit, my lord, I tried to contact with this, my lord, the petitioner, but presently he is posted at, my lord, Mokama in a, my lord, some election duty in Bihar or others. My lord, this 3 days or 4 days accommodation, it can be not this week, my lord, then.
But I have not granted any liberty to file supplementary.
That's true, but it is necessary, my lord.
No, I will consider this. If supplementary affidavit is required, I will grant it.
Very well. Great.
Not this week, Purga. Not this week.
Very well. Grateful. Item number 20.
Item number 20 was adjourned.
Yes.
But Passover lordship is Talam is on her legs.
Not today.
Lordship, she'll come.
No, it's not possible. At 3 p.m. other matters are fixed.
My lord, these matters your lordship has already, my lord, on.
Not today.
Not today. Come back on the next night.
Item number 21.
Not today. 26. Not today. 21. Same. Not today. There's height issue.
Lordship, height issue. 9th is the last date. 9th is the last date. That is the only problem, my lord. This is the third time adjournment was. Anyway, my lord, what can be done? Grateful, my lord. So,
Item number 23.
It will appear tomorrow. Let me see if I can take up this matter.
Milord, I am from the respondent side. My senior counsel is on the way. I'm paying for a short passover.
23, my lord, snap.
Item number 23.
Petitioner, yes, what is the matter about?
She's a widow, my lord. She's praying for release of her benefits, terminal benefit, including a family benefit.
My husband was working as a senior assistant, my lord, accounts, my lord, in the Indian Statistical. He died in the year 2022, my lord. Till that, my lord, it has not been released, my lord. All the formalities have been complied. Suddenly, my lord, they come up with my lord, I'm filing that.
When the employee died?
Well, he died, my lord, on May 27, 2022, my lord.
Yes?
May 27.
May 27th?
2022.
27th May 2022.
22.
So why you are coming after 3 years?
My lord, I have applied, my lord, kindly come see, my lord, in 22 only I applied, my lord. I have come here, my lord, because
already 3 years have passed.
Yes, my lord. My lord,
So why after such a long time?
my lord, she complied with all the formalities, my lord.
What formalities is required for getting pensionary benefits and terminal benefits?
Documents and everything, my lord. Everything was supplied, my lord. Suddenly, my lord,
In which post husband of the petitioner was working?
He was working in the post of assistant, my lord. Office
Assistant.
Senior assistant.
Senior assistant.
Account.
Yes, place the facts.
I have come with your lordship, my lord, because of Annexer P5, my lord, as page 25, my lord. After complying with all the formalities and submitting all the documents, my lord, they suddenly issue a letter, my lord, that I have to submit a succession certificate.
You are hereby requested to submit a succession certificate as desired by Article 14. After receiving.
Whereas page 21 says
You are the wife of the petitioner.
Yes, sir. Page 21, they are admitting, my lord.
Now, in the nomination, whether the nomination was exercised by the employee and a nomination was made in favor of the petitioner.
My lord,
in connection with the service rendered by the husband of the petitioner, whether there was an exercise of nomination.
Page 21.
Nomination. Whether the petitioner is the nominee.
My lord, she is the recorded wife of the husband in the service.
I am asking different thing. There is a generally you will find that in connection with service of an incumbent, there is a provision for exercising nomination.
That I am not aware.
Whether the petitioner is the nominee of the employee, retired employee.
But 21.
Nominee.
No, my lord. May I submit? My lord.
You will submit letter. It is his case. Allow him. Yes.
My lord, they after receiving application, my lord, they issued a letter, page 21, my lord, where they are saying, my lord, with reference to your letter dated 18th August 2022, intimating the death of your husband, I am directed to say that in terms of the ISI retirement benefit.
Page 21, you are reading.
21. ISI retirement benefit JFF pension cum gratuity scheme rules 1982 with amendments. A family pension is payable to you, a widow of late Shankar Badla. This fact they are not denying. But now, why she has come, my lord? Why? What has happened in the meantime, my lord? Kindly she come to page, my lord, 26.
For the amount of information will be submitted.
Response number 5 and 6, my lord. They are the brother-in-law and sister-in-law of the petitioner, my lord. They filed a writ petition before this honorable court, my lord, without implementing the petitioner as a party.
Without implementing. They filed a writ petition.
Yes, madam. Seeking shares in the provident fund and the gratuity, my lord. So since she was not made a party, my lord,
who are they? Brother-in-law and
the brother-in-law.
Sister-in-law
and brother-in-law.
Sister-in-law and brother-in-law of the petitioner.
Of the petitioner. This is employees brother and sister. Page 26, my lord, there was a direction to implement them as a party, my lord. And page 27, my lord.
Page 26.
26 and 27, my lord. 27 is the subsequent order, my lord. The details of the petitioner and her 5-year-old daughter was provided, my lord. And thereafter, she was directed to be made a party, my lord. And a writ petition has been served upon me, my lord.
Then what happened to this writ petition?
This is pending, my lord. This hasn't come up since then, my lord. So my prayer is, my lord, kindly take up this writ petition as well as the current one, my lord, so that matter can be adjudicated properly.
কি গ্রুপে করা আছে?
Well, I have inducted
just to
message.
Yes, why you have directed to produce a succession certificate?
My lord, first of all, I am appearing on behalf of respondent number 2, 3, and 4 as I am their legal consultant. A formal assignment has not yet been done. Formal assignment through ministry has not yet been done. But I know the facts of the case. Therefore, it will.
Yes. Why is succession certificate?
Yes, Your Lordship. During the
And during the lifetime of the wife of the employee, whether the brother-in-law and sister-in-law are eligible to get proportionate provident fund and gratuity.
No, Your Lordship. May
Then?
May please. Lordship, in the during the service tenure of the person, there is no mention of the existence of wife. And rather, in the nomination form of gratuity, it is mentioned that brother and sister will be available, will be eligible for the gratuity. Now, Your Lordship, it is a fact that later we came to know that this person is married. After
How you came to know?
Yes, Your Lordship. We came to know from a marriage certificate, which we wanted to verify. And even 3 days back also, we communicated with her that yes, we want to disburse the pension, but not the gratuity, since it is sub judice. And my lord, if you kindly see the earlier writ petition also, sister and brother.
Are you disputing the marital status of the petitioner?
Lordship, we wanted to verify only. And we want to release the pension because so far as pension is concerned.
Very well, take steps, come back. But since you have already disclosed your stand, VDA letter dated 26 September 2022, that the payable as we just a minute.
Family pension is payable to you, man.
VDA letter dated 13 September 2023 that a succession certificate is required.
Lordship,
So what?
In that tenure, when we were not aware that marriage certificate is valid or not, thereafter she came to our office
With marriage certificate.
Yes, but the latest position is.
Well, I am adjourning the matter for fortnight. In the meantime, you verify the documents of the petitioner. Ask the petitioner to appear before the concerned authority, verify the documents, and take a stand. And let it be disclosed before this court on the next date.
Yes, and another issue, Lordship, so far as this writ petition is concerned, 2 prayers are there. One is pension and gratuity. Gratuity matter, we cannot do anything because the matter is already sub judice. And so far as prayer A is concerned, we can take a step.
Because of the other writ petition, my lord.
But even court proceeds on the premise that the petitioners in other writ petition are brother-in-law and sister-in-law. They do not have any claim over the gratuity.
That is,
if you accept petitioner as wife and release family pension, then in that event, those brother-in-law and sister-in-law do not have any claim over the gratuity.
We understand, Lordship. This is our stand also, but we need one order because this matter is pending.
And I will direct another writ petition to appear along with this matter. I will direct the petitioner to inform the petitioners in those writ petitions who are the private respondents in this writ petition. In the meantime, you verify the documents of the petitioner and take steps for release of family pension.
Okay.
My lord, one indulgence.
No further today. Enough is enough.
No,
sorry.
Affidavit of
Affidavit filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner's husband was senior assistant of Indian Statistical Institute, who died in harness or after retirement.
In harness.
Who died in harness on 27th May 2022. Grievance of the petitioner is though she is a legally wedded wife, terminal benefits including family pension and death gratuity have not yet been released in her favor. Stop. Next paragraph. Learned advocate representing Indian Statistical Institute
formal assignment has not been done.
Has submitted on instruction that before taking steps to release family pension in favor of the petitioner, concerned authority of Indian Statistical Institute intends to verify the documents of the petitioner. Stop. Next paragraph, in view of such submission made on behalf of Indian Statistical Institute, leave is granted to the concerned authority of ISI to verify the documents of the petitioner by fortnight from date and subsequent and thereafter take necessary steps for release of family pension to the petitioner. Stop. List the matter under the same heading for further consideration on 22nd December 2025, when learned advocate representing ISI will disclose the steps taken in the taken in terms of the order passed today. Stop. Next paragraph. Another writ petition being WPA 19452 of 2024 be listed along with the present writ petition on the next date, as the said writ petition was filed by the respondent numbers 5 and 6 herein. You are representing respondent number 5 and 6 herein. Stop.
My lord, we are representing number 1.
You are not respondent number 5, 6. Respondent number 5 and 6 herein. Stop. Next paragraph. Learned advocate representing the petitioner in this writ petition is directed to serve notice upon respondent numbers 5 and 6, including copy of this order by 7 days from date, and file further affidavit of service on the next date.
My lord, I have a small submission, my lord, humble submission. That is, in this order, they have also written that the previous writ petition has been attached to this petition, but we haven't got it yet.
Very little appear. Next one.
Item number 24.
Regarding item number 24 and 25, Lordship, Brotin Kumar De.
One after another, 24, 25, yes.
Brotin Kumar De is appearing for the Brotin Kumar De is appearing for the petitioner, Lordship. I am praying for 1 day accommodation, Lordship.
My lord, I am appearing for the respondent. Lord,
Which respondents?
For the Union of India. All
Union of India.
All the parties.
Yes.
Now, my lord, I do not stand in the way of adjournment being granted. Lord, in that event, my lord, kindly take it up on the next Wednesday.
No, not this week. Why next week?
My lord, the reason is instructions. We need instructions.
Let the matter be taken up. If I find that further instruction you require, I will accommodate you. At present, not this week. Let it appear on Monday.
Monday. No, instead of Monday, can it be on Tuesday? Monday, my lord, it will be very.
Tell your junior to pray for accommodation. I will consider.
Very well.
Item number 25.
25, Lordship.
Same identical matter.
Same order, Monday, not.
Item number 26.
I'm
appearing on behalf of the petitioner.
Yes.
Filing the affidavit of service.
Who is appearing on the other side?
Serve them.
Use microphone.
Serve the respondents, but
Have you services complete?
Lordship, the service is complete.
Who are the respondents? Who are the answering respondent?
Lordship.
Director ITI.
ITI, Lordship, the chairman come managing director. Phone number.
Okay. Nobody is happening for the respondents. This matter was filed on 25th of November, when you have effected service.
Lordship, on 27th of November.
27th service is complete.
Lordship, upon the respondent numbers. Lordship, service is complete upon respondent number 3 and 4. The general manager is not complete.
1st December.
1st
December complete.
1st December complete, but nobody is appearing. Union of India is also not represented.
Union of India is not required. ITI is the, I know, my lord, there are a bunch of writ petitions were filed on this themselves. I've brought those orders also.
So therefore, in those matters who appeared for ITI.
ITI, I know that.
28.
26. I know I can give notice.
Some learned advocate who represents ITI.
Milord, another prayer, Milord, item number 249 of the monthly list. Milord, that is, Milord, another read, Milord, same read, Milord.
Very well, I will consider this matter on the next date. If I find that yes, that is required, then I will.
Because on a same order, Milord, can be both the read.
File your affidavit of service. Affidavit of service filed on behalf of the petitioner is taken on record in spite of service of notice. Respondents are not represented.
771.
Learned advocate
For
representing
Union of India.
learned in spite of service of notice. ITI is ITI Limited. ITI Limited being the answering respondents are not represented. Union of India is represented
Your
by
Lordship,
learned
Union of
advocate.
India is not a necessary party. Your Lordship,
Please wait. This Union of India is represented. Next paragraph. Learned advocate for the petitioner is directed to serve notice upon the learned advocate who usually represents ITI Limited, enclosing copy of this order by
28 February
8 December 2025. List the matter under the same heading for further consideration on 11 December 2025.
I'll give notice to the learned advocate.
Advocate. That is what I have directed. You need not file affidavit of service.
I mean, because in all the matters that advocate, Mr.
Very well.
Bhattacharya-
Serve notice.
Well,
Yes. Yes, Miss Alam.
Faster budget.
Yes.
Your Lordship, take it up to
Today, 3 p.m. matters are fixed. Let me see if these matters are.
Your Lordship, Monday, because my learned junior will not be here tomorrow.
Monday, there will be a difficulty because 9th is the last date for medical examination. That's why I have directed that the matter to appear. If it is not taken up tomorrow.
Your Lordship, regarding item number 26, one prayer was that Union of India is not a necessary party. Your Lordship, may his name because.
So that I will consider on the next date.
Much obliged, Your Lordship.
Then keep it for tomorrow. Because, I mean,
Yes, yes.
Item number 33.
33 I beg to appear on.
Well, I am appearing for the petitioner.
এটাই কি মনোজ পাশে আমাকে 1-2 বলেছে আমি ভেবেছি তাহলে আপনাকে জানাবো
Yes, place your case.
My lord, here by way of petition, my lord, I am challenging the order passed by the district judge. That is the impugned page 84 of my writ application.
I'm not interrupting. May I just indicate the learned district judge is not here today.
What can be done? Matter is fixed.
Page 84, order passed.
Page 84, order passed.
Order passed as per the order passed by this honorable High Court. Page 81, order passed by this honorable High Court. And then page 84 is the passed by the district judge. Here, page 81, direction has
Order
been
passed by the by this court in an earlier round of litigation.
earlier round of litigation.
Where is that order?
Page 81.
Yes. Now you participated in the selection process for the promotion to the post of LDC from Group D post. Now you are scheduled caste candidate,
Scheduled caste candidate.
but your candidature was not considered.
Consider. Then writ application has been filed, then order has been passed. Page 85, serial number 8. The district judge specifically stated in terms of point number 8.
Page 85.
85, serial number 8.
Yes, paragraph 8. Yes.
Paragraph 8. In terms of point number 8 of the objection, it is to be mentioned that as per office record, due to non-availability of SC/ST candidate with the zone, the SC reservation was carried forward in view of 6 of the schedule of the West Bengal Scheduled Caste and Scheduled Tribes reservation of vacancies in Services and Posts Act 1976. And serial number 10, that is in terms of point number J, it is to be mentioned that in order number 129/A dated 17/8/2024 at serial number 2 categorically, a category under unreserved is to be read as SC, as there has been a typographical mistake due to such and such.
In terms of point number J, it is to be mentioned.
That is page
The
60.
J of your representation.
Malad, that is their promotional list. Promotional list, that is page 71.
It is to be mentioned that the order number.
70, page 71, which is under challenge in the previous writ application.
No, in terms of point number J, it is to be mentioned that the order number so and so dated 17th August 2024 at serial number 2. Where is order number
71, page 71. That was under challenge in the previous writ application. District judge said that was typographical mistake, that will be SC.
Which one will be SC? Show me from 71.
2, that is Amar Kumar Rai, unreserved, vacancy number 30, unreserved.
It should be SC.
It should be SC. By way of order, the district judge declared the same. And
so why you are not considered? You are SC candidate. Now, it is also stated that in terms of point number C of the objection, it is to be mentioned that as per office record, the group D employees above the age of 50 years as on 3rd October 2023 were exempted from computer test video number so and so. However, they must be capable of writing, otherwise they cannot perform any job.
We are not in that category. My grievance only serial number 8. That is no SC candidate found. For that reason, promotion was not given. We are the SC candidate. And now
There is a single petitioner or there are two petitioners? Three petitioners. Where are their names at page 71?
71, they are not, their name was not appeared. For that reason, that was challenged by way of writ application, and writ application.
All the three petitioners participated in the selection promotional process.
And now, my lord.
Now, if that again serial number 2
Yes.
at page 71, if this post is to be considered as SC, then there is one post. How three petitioners can be considered?
Other posts are there.
Where?
They convert into a unreserved post. SC post from
So,
SC post.
is it what is your contention? The post which is again serial number 2 is the only SC post, or there are other SC?
There are other.
Where are those posts?
There are
From 71?
Yes, there are other posts. My lord, if your lordship kindly see report filed by the district judge.
It was affirmed on 15 September 2025.
Yes.
Place it.
Page 15. First, it starts from page 11, page 13. That is the resolution of the meeting dated 24/7/2024 of the District Recruitment Committee, District Judge Office.
Page 13.
Page 13.
The District Recruitment Committee, District Judge's Office. Yes.
Straightway, your lordship, come page 14. Group
14.
D, page 14, Group D employee under zone of consideration.
For promotion to LDC.
Yes.
Yes.
Page 15, our serial number 38, 42, 44.
38.
42, 44.
These are the petitioners.
These are the petition.
Yes. Just a
And
minute,
then-
just a minute, the chief administrative officer has produced a prayer. So you were under the zone of consideration.
We are
In
the zone
terms
of
of the table appended to paragraph 3.
Yes.
Yes, then
Then, my lord, straightway, your lordship, kindly come page 26
of the report.
of the report.
Yes, page 26.
That is the resolution of the meeting dated such and such of the District Recruitment Committee, District Judge Office, Coach Bihar. Next, bottom, performance of the Group D employee in the minimum fitness test. That is the result. My lord, my name, page 28. (38, 42, 44). And last column, if your lordship kindly seen, last column, that is ESES. ESES for which category? Then your lordship kindly come page 26. What is the category?
Fitness criteria, yes, no. So secured minimum fitness criteria.
So that is yes.
In the written test.
In the written.
Handwriting test.
Computer typing.
No, computer is not, it was exempted.
Above 50.
Oh, you are not above 50. So you participated in the computer test as well as handwriting.
Yes.
And the minimum fitness test was qualified by the petitioner. Now, how many posts, reserve SC posts were there?
My lord, then my lord, kindly see for a moment.
Yes, yes.
Page 29.
Just a minute. Page 29 of the report.
Of the report.
Yes.
First para, second. List of successful Group D employees who have achieved the minimum fitness criteria. Our name was not there.
List of successful group D employees.
If your lordship kindly see for a moment, serial number 6, the name of the Ronojoy Chandra. Serial number 6.
6.
Ronojoy Chandra.
Yes.
Whose words written in type in 10 minutes, that is 111.
What?
And kindly come turn, my lord, page 27 for a moment.
Spelling. 111 is to 30. 90. Yes.
Page 27. That is words written, words type.
Page 27.
Page 27,
28.
serial number 10. Page 27, serial number 10. The Ronojoy Chandran at marks. 111.
Yes, yes.
111. And page 28, our written qualification. 109 first, 42 is the 163.
No, 38 is 109.
Below, I am not 111 below, that is 109. I am not on that. 42, what I computer type
163.
63, that is above. Then 44
Then
semester.
the next column represents, just a minute. Words wrongly typed, wrongly written /type. That is in case of candidate against serial number 42 163 2, then yes.
Yes.
Then 124 6, yes.
Yes.
So according to you, both are above
Ronojoy. And then, my lord, your lordship kindly.
But in the list at page page 29, your name is not there.
Not there. Our name not there. Ronojoy Chandra qualified. Then page 31. What they done?
Page 31.
Serial number 8.
What is this? 50-point roster of LDC?
30, my lord, that is the 50-point roster of LDC is occupied up to 28th position. So the aforesaid candidates under serial number 1 to 16 will be placed as follows. That is also the selected candidate, name of the selected candidate, whose name appearing in 29.
Yes, selected candidates.
Page 31, serial number 8.
Yes.
That is caste unreserved.
Yes.
Vacancy number 36 is scheduled caste. Scheduled caste vacancy, my lord, turned into a unreserved category. And these,
so these are there were 16 posts.
16
including
posts.
Reserved, unreserved.
Including reserved, unreserved.
Now I am asking you how many posts were earmarked for reserved category candidate, scheduled caste category candidate.
My lord, that was not disclosed anywhere.
But against serial number 8, it is stated scheduled caste.
Scheduled caste, that was scheduled caste turned into an unreserved. And serial number 15, same.
So Devashish Sharma was unreserved category candidate.
Scheduled caste category, in scheduled caste category,
he was considered.
Considered. And serial number 15 also, that is Khayabar Hossain, scheduled tribe category, that is vacancy for scheduled tribe, unreserved category appointment has been done. And what the district judge said, next para, the position number 36 was fixed for SC. Due to non-availability of SC and ST with the zone, the SC reservation is carried forward up to position number 40, where we put Sri Kollan Rai. There was a vacancy, there was a selected candidate, we are the selected candidate, we also achieved performance, all the criteria we fulfill. District judge declared that no suitable SC candidate is there, so they are not giving any promotion. And scheduled caste scheduled caste post has been converted into unreserved category and general candidate has been given appointment, promotion.
No, the position number 36.
36.
Where this position is referred to.
8, serial number 8. My lord, kindly see vacancy number 36. Serial number 8.
Number 8.
Yes, Devashish Sharma given appointment unreserved category. Then
Yes.
vacancy number 36. This vacancy number 36.
Just a minute. Position. This is fixed for SC. Up to position 40, where we put C colon. Now, this is the list of selected candidates. Then just consider serially one after another. Unreserved, 1, again serial number 1, unreserved. Unreserved, then unreserved. Fourth vacancy was scheduled caste vacancy. Fourth candidate, vacancy number 32 under 100% roster was a scheduled caste vacancy. Page 30.
Page 30. Yes, that is 1, 2, 3, 4. 4 is the scheduled caste.
At the middle, it is written scheduled tribe.
Scheduled tribe. 4 also.
Then 36 vacancies scheduled caste.
Scheduled caste. That is 8. Serial number 8.
That is serial number 8.
8.
Then 40th vacancy scheduled caste.
Scheduled caste.
That is serial number 12.
12. Then 15. My lord, that was scheduled tribe. They converted unreserved. Then my lord, one general category.
Here, court is considering only claim of the petitioners where all the petitioners are scheduled caste candidates.
Scheduled caste.
There is no scheduled tribe candidate.
No. All are.
Now, how many from this list? A list is there at page 30 and 30, pages 30 and 31. So from this list, how many scheduled caste candidates vacancy were converted into unreserved category?
My lord, these by way of this report, my lord, this was
PS 4, then serial number 8.
3, 4, 5.
5.
5. My lord, that is 4, serial number 4, serial number 8, serial number 14, serial number 15. 4.
No, serial number 14 is unreserved.
Unreserved. Serial.
Only 2 vacancies are there.
Yes.
Only 2 vacancies for scheduled tribe. That is 4 scheduled caste, and then serial number 8, that is vacancy number 36. It is also scheduled caste. Scheduled caste. And another vacancy is there. It is scheduled caste is 40. Then scheduled caste, it is 3 vacancies. Vacancy number 32, vacancy number 36, and vacancy number 40.
40. 40. That is Kollan Roy given appointment.
So therefore, your case is this, that you participated in the promotional examination. You have all the candidates are scheduled caste candidates, but respondent authority proceeded on the basis that there was no scheduled caste candidates found eligible to be appointed. As a result of those vacancies were carried forward, but against those vacancies, other candidates from unreserved pool were appointed.
And this was first disclosed by way of report.
No, prior to that, in the impugned order, come to page 85. Read paragraph 8, page 85.
In terms of point number H of the objection, it is to be mentioned that as per office record, due to non-availability of SC/ST candidate with the zone, the SC reservation was carried forward in view of 6 of the schedule of the West Bengal Scheduled Caste and Scheduled Tribes Reservation of Vacancies of Services and Posts Act 1976.
Then in terms of point number 1, the objection is to be, point number I of the objection, it is to be mentioned that 51%. In terms of point number J, it is to be mentioned that the order number so and so, serial number 2 category is to be read as SC. Serial number 2 category under unreserved. You have demonstrated just now that which vacancy was serial number 2 category under unreserved is to be read as SC. Where is that?
Page 71.
T1টা জজ সাহেব জানতে চাইছেন মানে এটা যেটা আপনি দেখালেন না এটা
হ্যাঁ।
জজ সাহেব জানতে চাইছেন
Serial number 2 unreserved.
মনে হয় ওটা
Unreserved is to be read as SC. So therefore, this carry forward of vacancy was not required in view of availability of the petitioners as civil caste candidates who now another point that in terms of point number H of the objection, it is to be mentioned that as per the office record due to non-availability of SC/ST candidate within the zone. So what is the zone?
Well, zone of
That is based on the performance of the candidate.
Yes.
Yes.
Zone of consideration, well, that I just now I showed you lordship. Zone of consideration, my name was there. That was page 13.
30.
13. Page 14 is the zone of consideration.
Report.
Report. Page 14 is the my employees under zone of consideration. Page 14. Group D employees under zone of consideration. That is our name is 38, 42, 44.
$38, 42 and 44.
44. And the result as per their report, page 28. That
Then
whether
performance of the group D employees in minimum fitness test.
minimum fitness test.
There, according to Ranojoy Chandra's name should have been performance is below the performance of
Yes.
at least two
Yes.
of the petitioners.
And our name is there, page 28. All are yes. Minimum fitness qualification already I achieved. Serial number 32, 42, 44.
Petitioner name of the petitioners against serial number 42 and 44, page 28 of the report. They performed better than Ranojoy Chandra.
And 38 also achieved minimum fitness criteria. Yes. And
So is there any cutoff? Is there any yardstick fixed relating to?
that was not disclosed anywhere by the district judge. I made representation and to publish the same, they are not publishing anything. And the number which we achieved, that was not also published in earlier writ petition also. Now after your lordship direction, my lord, by way of report, they disclose this report that we achieved our minimum fitness criteria. That was first time disclosed.
The first time.
Yes. That was first time disclosed by the district judge. And we know from this report that we achieved the minimum fitness criteria.
What is the minimum fitness? No, I'm asking you, is there anything disclosed in the report that what is the cutoff level
That was not disclosed anywhere. That was not disclosed.
for reserved category candidates?
Nothing.
Viral, if necessary, I will hear you. Yes, district judge. He is a high court. He did not conducted the process. District judge conducted. What the high court will say?
So kindly allow me Milord to explain. Milord, I'll explain from his report only. I'll explain from his report. Kindly Milord take the rules. Milord, the rules my learned friend Milord has annexed. It is there Milord at page 32. These are the rules
32 of the writ
of the writ petition. That Milord guide the Milord selection process, the promotion process. 2015 rules, page 32.
Which has been referred to by the district judge in the impugned order.
And my learned friend also, Milord, in his writ petition saying that these are the rules which have been violated.
And his prayer is, her prayer is rather, my lord, that these rules should be followed. That is her prayer also, prayer A of the writ petition. So these are the rules.
On the anvil of facts, Mr. Wong.
I'm sorry, my lord.
On the anvil of facts.
Yes, absolutely.
Yes.
Absolutely. Now, my lord, kindly turn to, it starts at page 32. Kindly, my lord, turn to page 40.
Page 40.
40, my lord, of the writ petition.
Yes.
My lord, towards the middle of page 40, rule 22, subclause B for Bombay.
Procedure of recruitment.
My lord, may I place it?
Yes. Yes. Yes.
Procedure of recruitment. The opening words are, subject to the provisions of these rules, the recruitments to any category of post in the service shall be made by the appointing authority. Then, my lord, A is in case of direct recruitment, we are not concerned because this is a promotional recruitment. In case of recruitment by promotion, my lord, this is then important.
Yes.
On the basis of seniority cum merit, that is, seniority subject to minimum fitness of the candidate to discharge the duties of the post from amongst persons eligible for promotion. So, my lord, the criteria is seniority. Seniority cum merit. So, my lord, merit takes the back seat once, my lord, minimum fitness is achieved. My lord, to put it, my lord, in a more, my lord, clearer way, my lord, if today, my lord, my learned friend is senior to me, and my lord, the minimum fitness is, my lord, let us assume scoring, my lord, 20 out of 100. I scored, my lord, 80. My learned senior friend scores, my lord, 50. But, my lord, since both of us have achieved the minimum, my lord, fitness level, my lord, my learned senior friend being senior to me will automatically get the recruitment.
Irrespective of the marks.
Yes.
But the only condition is
Minimum
this,
fitness.
that the cutoff level has to be achieved.
Floor level, my lord, is to be achieved. That's, my lord, the law.
If it is 20 is the cutoff marks out of 100,
even if I score full marks,
if A gets 30, B gets 40, but if A is senior than B,
A will get it.
Yes.
That's the law. Now, my lord, kindly turn to page 44. How, my lord, seniority is to be recorded?
Yes.
44, 44. Towards the end of, my lord, page 44, rule 41. I'm sorry. My lord, at the bottom of page 44, rule 41. Seniority. An employee appointed in accordance with these rules of recruitment on regular basis shall be senior to persons appointed temporarily on or as local candidate. Where employees are recruited to a cadre by promotion and direct recruitment, the officers recruited by the promotion shall take precedence over the directly recruited candidate. Save as provided in sub-rules 4 to 7, seniority of employees appointed by direct recruitment or promotion shall be determined according to the dates on which they report for duty. So, it's the gradation list.
Just a minute.
I'm sorry, man.
Yes.
So, my lord, date of entry into a particular cadre will decide the seniority. My lord, comparative seniority. Now, my lord, kindly turn to page 58. Rather, my lord, page 53 first. Then, my lord, page 58.
Page 58.
53, my lord, first. In the service copy, page 54 is missing, but that's not relevant though. Page 53. Clause, my lord, 63. Application of other rules not inconsistent with these rules In all matters not expressly provided for by these rules, the rules specified in the West Bengal Service Rules and other service rules applicable to government employees, insofar as they are not inconsistent, should have been inconsistent with these rules, shall mutatis mutandis apply. My lord, I show this because, my lord, there was a government notification letter which was made applicable. So, my lord, WBSR applies, provided that is not inconsistent with any of the provision of these codified rules. Now, my lord, kindly turn to page 58.
Page
58. There are 2 page numbers given in each page. My lord, kindly take the bold
Yes, page 15.
pagination. Yes. My lord, Schedule C. Yes, Schedule C for Calcutta. Kindly take the first table, second entry, serial number 2. My lord, the heading of this table is Method of Recruitment and Qualifications of UDC and LDC or other equivalent post. My lord, we are concerned about LDC. Kindly take serial number 2. Lower division clerk or typist erstwhile, typist copies erstwhile, other equivalent posts. My lord, method of recruitment under the second column, rather third column is 75% by direct recruitment. And my lord, we are concerned with, my lord, clause B, 25% by promotion from the cadre of process server, summon bailiff, seal bailiff, attender, etc. and other equivalent posts having, my lord, madhyamik, etc. etc. Now, my lord, kindly take the next column, qualification. Must have passed madhyamik, then, my lord, B, this is important, minimum fitness test. Must have passed typing test or have such knowledge or qualification in computer operation as may be specified by the High Court at Calcutta from time to time. So, my lord, a typing test is the minimum fitness test.
Yes.
Now, my lord, kindly take, my lord, the notification at page, my lord, 62. This is, my lord, though that not that important, but I just show your lordship, page 62. My lord, this is the order of 3rd October 2023, passed by, my lord, the district judgeship. Kindly turn to the next page. My lord, second recital of, my lord, page 63. And whereas taking into consideration of the existing staff strength and process server vis-a-vis number of vacancies to be filled up in terms of aforesaid existing notifications read with 63, Rule 63 and Rule 22. These are the rules which my lord has just now seen. Of the 2015 rules, the following candidates come within the zone of consideration. Where, my lord, my learned friends, clients, my lord, featured. And, my lord, the persons who have got appointments, my lord, they also featured. Now, my lord, kindly take the report of, my lord, the learned district judge. So, my lord, those were the rules. And then, my lord, that notification, my lord, who come within the zone of consideration indicated. My learned friend was initially indicating that, my lord, her clients were not, my lord, brought within the zone of consideration. That is not correct. They were brought, they sat in the examination. Now, now kindly take, my lord, page 11 of the report.
Yes.
My lord, I skip over the first paragraph. Kindly take the second paragraph. After careful consideration at page 11, my lord. After careful, this is, my lord, a notification from the government. My lord, I have shown to your lordship, my lord, that the WBSR and the notifications were made applicable, provided there is no inconsistency to the, my lord, rules. My lord, this memorandum was made applicable. Kindly take, my lord, second paragraph. After careful consideration of the matter, the undersigned is directed by the order of the governor to say that the governor has been pleased to decide the following. As per existing provisions of the employees appointed to the post of LDA, LDC on promotion from Group D, etc., during the period from such and such till date, are liable to pass examination on computer operation and computer typing. Such employees shall be exempted from passing the same on attaining the age of 50 years, and on passing the same or being exempted from passing the same, they will be allowed all increments due to, etc. So, my lord, if they cross 50 years, my lord, exempted from the typing test. Kindly take then 3.
Just a minute. Yes.
Then, my lord, clause 3, I am skipping over my lord Roman 2. Kindly take Roman 3. Says, my lord, they have to pass, my lord, computer test. That's the minimum fitness test which was, my lord, adopted. Now comes, my lord, the resolution at page 13, my lord, under which the
Now, what is the position that a computer test has to be cleared by
above 50 years, below 50 years of age, they have to sit, my lord, for
Yes.
computer test. What will happen to those people who have, my lord, attained 50 years or above 50 years? That, my lord, will kindly get at page 13.
To pass examination to
Page 13, my lord, is the resolution which my learned
Now,
friend
what
has-
does it say? That such employees shall be exempted from passing the same on attaining the age of 50 years, and on passing the same or being exempted from passing the same, they will be, and on passing the same or being exempted, and on passing the same or being exempted from passing the same, they will be allowed all increments due prior to passing the same or being exempted from the same, as the case may be. Define, Mr. Magic.
My lord, kindly do not go by the language. My lord, I am going by the tenor. My lord, nobody is disputing that. If I attain 50 years, I cannot
I
be
am exempted
from
from
computer
participating
test,
in computer
typing test.
computer operation and computer typing.
Right. So, my lord, then how my fitness, my lord, would be tested? My lord, there remains a vacuum. My lord, that is answered in page 13.
Page 13
of this report. My lord, kindly skip over 2-3 pages. Those are not important as of now. Kindly take page 16. My lord, this is a resolution taken by, my lord, the District Recruitment Committee. Page 16, clause 5. My lord, Courts Rule 22, minimum fitness. Then, my lord, clause 6. Clause 5 only quotes, my lord, Rule 22. Then, my lord, clause 6. In view of the aforesaid provisions of rules, the promotion to the post of LDC from gradation list, kindly, my lord, mark this. So, the seniority would be reckoned from the gradation list of Group D and process server should be made as per the seniority cum merit along with minimum fitness to perform the job. Then, my lord, 7. The candidates aged more than 50 years are exempted from computer test.
In just a minute.
I'm sorry.
In view of the aforesaid provisions of rules. The post of LTC. August 2017. 4th August 2017. Yes, yes. 6 then.
Then, my lord, 6.
Yes, 6 you have
6,
read.
my lord, has seen. Then 7. Says Milord above 50 years exempted, same thing.
Is aged above 50 years are exempted. Yes, 50 years exempted.
Then Milord's page 17, next page, clause 10. Milord, this Milord assumes importance. Milord, the district committee is saying, bearing in mind the aforesaid principle and in view of the aforesaid notification, read with Rule 22 and 63 of the 2015 rules and provisions of law, we unanimously decide that the candidates belonging to Group D and process server who are eligible to be promoted to LDC should be competent enough to perform the job of LDC. The parameter of granting promotion cannot be on the basis of seniority only, ignoring their ability to perform their job as per 22B.
How this can be done?
Will they say?
It is not the contemplation of 22B and the notification memorandum dated 4th August 2017.
Clause
And if this is allowed, then this will invite illegalities.
Millard, clause 10 is not saying, Millard, I will ask.
How the additional district judge or district judge is empowered to do this according to their sweet will?
I tell you, Lordship Millard. Clause 10 is not.
Let us again read it
Yes.
to understand.
Yes.
Now it appears that this is the root of everything. This decision is the root of every. Yes.
May we read it?
Just a minute.
May Millard, we read it once more. We unanimously decide. May Millard read it up?
The aforesaid principle and view of the aforesaid notification to the court to read with Rule 22B and 63 of the district provisions of the district decide that the candidates belonging to and process server who are eligible to be promoted to should be competent enough to be competent job should be competent enough to perform the job. Should be competent enough to perform the job. Parameter of job as well. Now, this competency, competent enough, this
How that is to
competency
be
is to
decided?
be adjudged based on handwriting test.
Yes. Page 20, clause 21. So, Millard, what the recruitment committee said?
Let us go back to Rule 22B and 63.
Yes. Kindly take the rule.
Page 40.
Page 40.
Fitness of candidates to discharge the duties of the post. Then 63B.
Millard, page 53.
Yes. No, page 53.
Yes. Which Millard I have already shown to your lordship.
Yes.
Then Millard schedules the.
Just a minute.
I'm sorry.
No one does not accept.
বাবাকে হাসপাতালে নিয়ে গেছে, একবার ফোন করে জিজ্ঞেস কর বাবা কেমন আছে। ছোটকাকে ফোন কর। হ্যাঁ হ্যাঁ, জিজ্ঞেস কর।
Now come to page 58.
Yes, Milord.
So it is provided in the schedule itself.
Correct. So, Milord,
there must have passed typing test or have such knowledge or qualification in computer operation as may be specified by the
Right.
High Court at Calcutta from time
So,
to
Milord,
time.
when this schedule was framed, Milord, the government notification was yet to come that exempted, Milord, elderly people from sitting in the, Milord, computer test, because, Milord, they are not supposed to know computer. They are elderly people. That was the idea.
No, but that you are saying based on 63.
Yes.
Based on 63. Now 63 says that in all matters not expressly provided for by these rules. The rules specified in the West Bengal Service Rules Part 1, Part 2 and other service rules
Mutatis
applicable to
mutandis
the-
will apply.
Yes, apply.
So, Milord, we applied, Milord, the notification of the government saying that elderly people we can exempt. But there would be, Milord, another mode of fitness test for them. Instead of typing, they should write it by hand. Because, Milord, they are going to sit in the Ejlas with the learned judge. If they can't write English, can't type English, then, Milord, they can't perform their job.
Where from you are inputting this handwriting test?
Yes, page 20 of the report. Milord, I was slowly taking to your lordship. Now I directly take your lordship to that. I was slowly taking, Milord, by one. Kindly now come to straightway to page 20 because my lord has now understood, Milord, what was there.
I am trying to.
My lord has gripped it. Milord, I am sure. Page 20, clause 21. And the reasonings are given in the previous pages. Excellent.
This is by way of resolution.
Yes. And they sat in the examination on the basis of this resolution.
But that is typing test.
No. Kindly take. My learned friend is agreeing that. My learned friend is agreeing.
That is
It is
all
for above 50.
above 50. We are below 50. No. We are not above 50. We are below 50.
Dada, एक second. They are below 50. Milord, elder.
For them, this handwriting test is not contemplated.
No.
Now let us again go back to 60 rule 63.
They are below. Onno matter they are above. Some of them are above. Right.
Don't lay your ears to others. Let us go back to page 40.
Yes, Milord.
No, better straightway come to rule 63.
Very
And
well.
the schedule. Schedule is the methodology prescribed
Absolutely.
in the schedule. Just a minute.
No.
Page 58.
58. Typing test.
Must have passed typing test or have such knowledge or qualification in computer operation as may be specified by the High Court of Calcutta. Petitioners participated in the typing test as well as computer test.
Milord, why I was showing that? My lord is taking up two matters. Milord, both are identical. This matter and the next matter. Milord,
The next matter, petitioner is above 50.
some of them. So, Milord, if my lord takes into consideration these rules, Milord, the second matter will also, Milord, my lord need not hear us then, Milord, anymore. So, Milord, above 50, handwriting, below 50, typing.
Only handwriting, below 50. Now,
Page-
above 50, handwriting. Then below 50,
Computer.
typewriting plus computer test.
Typing on computer.
On computer. It's a same examination. There is no
Yes,
separate
same.
computer test.
They
Must
need
have
not-
passed typing test or have such knowledge or qualification in computer operation as may be specified by the.
Milord, either someone will dictate them a paragraph or a passage, or Milord, a literature would be circulated. Someone will, Milord, type it on the screen. Someone will write it on the paper.
That is exempted for those exempted so far candidates above 50.
50, of course.
Yes.
Otherwise, Milord, the rule is if someone achieves the minimum, the floor level, the senior will get the first chance. Now, Milord, kindly come to the result.
Page 20.
Page 20 shows, Milord, that For the elderly people, handwriting is the
Where
text.
it is
Clause
decided.
21 at page 20 of the report.
Yes, that you are about to place it before this court.
Yes, Milord.
I intervened and I took you to 63
Yes, Milord.
and
I'm grateful,
schedule.
Milord, for that. I'm
Yes,
grateful.
place it.
The Group D employees, page 20 of the report. The Group D employees above the age of 50 years, as on such and such, Milord, the date matches with the date of the notification, are exempted from computer test as per notification as indicated above. However, they must be capable of writing, otherwise they cannot perform any job as LDC. So, the minimum criteria is considered, according to us, in the event they are capable of writing in English, are considered to be eligible for promotion. The assessment will be made by giving the typed English paragraph of 100 words, which is to be written by them in hand within 10 minutes.
But that exercise is not questioned by the petitioner.
No. But I'm showing that exercise is not questioned by them. What they are, Milord, challenging that they have scored higher than who have got the job, who have got the promotion.
Not only that.
And Milord, this migration.
Reservation.
And migration.
Because the posts which are reserved for scheduled caste candidates, due to availability of the scheduled caste candidates, how this can be carried forward?
This was not carried forward, at least what transfers from the report. Milord, what I could understand, subject to my limitation of understanding, my learned friend Mr. Mukherjee can explain it better because Milord, his report. But Milord, kindly now come to the report. Milord, the result. Milord, I straightway take your lordship, Milord, to the names of the persons who have got the promotion. Kindly
To that
take.
extent, I can understand that yes, below 50, typing test on computer, above 50, exempted from typing test as per Schedule C, and it was decided that they are to participate in handwriting test.
Yes.
And
Milord, the yardstick is
prior to that, petitioners and selected candidates were within the zone of consideration.
Yes.
As the list published.
Yes.
Now the problem is with regard to reserve.
Milord, I'm coming to that. And Milord, the yardstick was only seniority, provided they are capable of doing the job, minimum fitness test. Milord, the marks obtained is otherwise of no relevance.
Yes, once a candidate
crosses Milord the floor,
minimum level or the threshold point,
marks become irrelevant.
Marks become irrelevant. Who is senior, he will be given promotion.
Yes.
That is the concept of seniority come
merit.
If it is merit come seniority, question would have
Just the
been
reverse.
Just opposite.
Just the reverse. I'm grateful to your lordship. Now, Milord, kindly.
Suppose 20 is the threshold mark. Now, A gets 40, B gets 50. But if A is senior, to B, A will be promoted.
Milord, the philosophy is, Milord, A would retire first. B will again get a chance to get promotion. Now, Milord, kindly take page 30.
30?
Yes. Milord, 50-point roster was being followed.
30 of the writ petition?
No, of the report.
Report.
I'm sorry, of the report. Milord, my learned friend also admits that 50-point roster was the roster.
Yes, it is also disclosed in the
Page 71 of the writ.
Yes.
Milord, the roster stopped at 27th position of the 50-point roster, which is why they are starting from 28th point. That's indicated at the foot of page 30. Last paragraph, immediately above below the table, the 50-point roster of LDC is occupied up to, oh, I'm sorry, Milord, up to 28. So, Milord, from 29.
29. Yes.
Now, Milord, kindly quickly see, Milord, how many posts were available for the SC candidates going by the roster starting at 29th point.
Then 32, 1.
Milord, 29th is 1.
No, this is unreserved.
Unreserved.
Scheduled caste.
Correct. I'm sorry, Milord, 30. My lord is absolutely right. Milord, I was wrong.
32 unreserved, this is 1.
32 is 1.
The 32 scheduled caste 1.
1.
Then straightway come back
36.
to 36. Scheduled caste 2.
Then Milord,
then scheduled caste 43. See, third post.
40, Milord, 40.
Yes, 40 is the third post.
Yes.
Under the scheduled caste category.
And that's all.
Under 150-point roster.
And that's all.
And thereafter scheduled tribe 43.
Milord, we are not concerned.
Yes.
So, Milord, there are 3 posts available.
Right.
Milord, 32, 36 and 40.
Yes.
Kindly see, Milord, who have been, my lord, appointed as scheduled caste category candidates, my lord, in this table. Kindly take, my lord, Shomir Das.
Where from you are getting this?
My lord, in
From
the
the
same,
state table
in the
at
same
page
table.
31.
Same table, yes.
Yes, against scheduled caste, vacancy number 32, Dineshwar Rava.
No, my lord, kindly take 29th point. My lord, that was for unreserved category.
Names of the employees.
My lord, that same table my lord was looking at.
Yes.
Kindly take the first entry, Mr. Sri Shomir Das, process server.
Right.
His caste was scheduled caste. He belonged to scheduled caste category. But my lord, this post was for he was more meritorious. My lord, he migrated. That's the law. My lord, if I, despite being a scheduled caste, my lord, I can compete with the general category, my lord, I will be treated as a general category. Huh. Then, my lord, this Amar Kumar Roy is same. Then
they were considered as a scheduled caste candidate, but
in unreserved post.
achieved better position.
Yes.
So therefore, they could compete.
So
with
my
the,
learned friend cannot be, will not complain against them.
The question of complaint
Does not arise. Does not arise. I'm so grateful. Now, my lord, kindly take Dineshwar Rava. Kindly see, my lord, his position in
whether
the
he is a scheduled caste category candidate.
He is ST.
Then
Below,
how he can occupy?
My lord, below ST, below SC. My lord could compete with SC. So my lord migrated. My lord, general, scheduled caste, scheduled tribe, OBC. My lord, that's the hierarchy.
If any candidate is scheduled tribe candidate, he can, if he achieved a marks or achieved a level, if he achieves a level by which he can compete with general category candidate, in that event, Mr. Banerjee, he will be permitted to occupy a seat or a vacancy
in the general category,
which is reserved for general category. Correct. But he cannot occupy a vacancy of scheduled caste category.
My lord, I go by that. Then, my lord, my learned friend's case is even weaker.
Yes, that I am not concerned.
My lord, I was arguing.
I am not here to fortify the case of your learned friend.
I'm so grateful. Then, my lord, kindly let us take.
I am asking you vacancy number 32 scheduled caste.
But a scheduled tribe.
How this petitioner, this candidate was permitted to
would have been considered.
Considered.
My lord, my learned friend will answer that. Mr. Mukherjee.
No, you have to answer it. That is the crux of the issue.
No, my lord, let us assume. My lord, I'm sorry. My lord, let us assume that a scheduled caste candidate, my lord, occupied this post. Yes. Instead of scheduled tribe candidate, a scheduled caste candidate occupied this post. In a hypothetical situation, 3 posts were available, my lord, for the scheduled caste category candidates. So, my lord, these would have been occupied by 1. 2 would have remained.
These candidates are called own merit candidates.
Absolutely.
And they can occupy the vacancy of an unreserved candidate.
Not of
scheduled caste category candidate.
Not of another reserved category.
Scheduled tribe category candidate cannot occupy the vacancy of scheduled caste.
My lord, let me assume that this was a wrong appointment. Let me assume his appointment is not under challenge as of now. The recruitment process as a whole is also not under challenge.
But there is a cascading effect, Mr. Banerjee.
No, there would not be. There would not be, my lord. May I explain that to your lordship?
Yes, explain.
Yes. My lord, my lord, take a hypothetical situation where, my lord, a scheduled caste candidate, my lord, occupied this vacancy number 32. Then, my lord, 2 more would have been left in the scheduled caste category.
Yes, there is total 3.
Total 3. So, my lord, then for this, my lord, Dinesh Rava, he is, my lord, much above in the gradation list than, my lord, these petitioners.
Either he is to occupy a seat of scheduled tribe or general, but not scheduled caste.
My lord, my learned friend has to show that, my lord, somebody below them in the gradation list, my lord, had occupied a seat. My lord, infringing his right. Yes.
That is not the case. Case is this: there are 3 vacancies reserved for scheduled tribe categories. Now, in case of scheduled tribe categories, there is a threshold point fixed.
There is no threshold point.
If it is not fixed,
a minimum level.
Down a minimum level. Now, if petitioners are the scheduled caste candidates, in that event, how petitioners' right to be considered against scheduled against those reserved vacancies earmarked for scheduled tribe candidates can be relaxed. And there was a decision taken to carry forward to the next
I could not
selection process.
Sir, because of my limited understanding, I could not make any sense of that paragraph 8. I could not make any sense. My learned senior friend will explain that.
Now you tell me now things are boils down to this. Now there are three posts.
Three posts. And
now so far vacancy number 32 is concerned.
Yes.
It's a case that there was non-availability of scheduled caste candidate as a result whereof scheduled tribe candidate was accommodated. Simple question.
Possibly no. Documents do not say that.
If documents do not say this, then how Dineshwar Rava was permitted to occupy this was permitted to be adjusted against a scheduled tribe post, a scheduled caste post?
My understanding was since scheduled tribe was more meritorious than scheduled caste, so
no,
that was my understanding.
Suppose an OBC candidate, he gets higher marks. Whether he will be permitted to occupy a seat reserved for other category candidates, or a scheduled tribe candidate, whether he will be permitted to occupy the seat of scheduled tribe, scheduled caste and OBC? Answer is no. Only he can occupy, own merit candidate can occupy a seat reserved for unreserved category candidates.
Right, follow. Let us make it.
Now come to page serial number 8. Come to serial number 8, Mr. Mahanji.
Can I try to make it a little simpler?
No, please come to. I will give you opportunity. No issue. Please come to serial number 8. 8.
Yes.
This is the second scheduled caste vacancy. This was given to Devashish Sharma. Whether he is a scheduled caste candidate, tell me.
Says unreserved.
How he can be permitted to occupy a seat earmarked for scheduled caste candidate? And your district judge, not your district judge, the district judge says that there is no candidate found under scheduled caste category candidate. Please consider the impugned order. Paragraph 10 or 8.
Which was impugned in the first round of it. Yes.
That there is no candidate available under scheduled caste category.
That's possibly wrong. Possibly. I'm not quite sure. The learned district judge will explain.
Now you are saying that the post which is occupied,
three posts. Three posts were available.
Now we are concentrating on vacancy number 36. Vacancy number 36.
Yes.
Now vacancy number 36.
An unreserved category candidate
scheduled caste candidate where petitioners are available.
Somebody even above than the petitioners are available.
It may not go to the petitioner. It may go to other candidates.
Whether petitioner's right were infringed or not. I am on that. This is an adversarial litigation.
Question is
fighting a public interest.
Question is while appraising the facts, if it is found that something wrong has been done,
my lord,
court has the power.
Court
has ample power to correct it.
My lord can intervene.
That may not directly benefit the petitioners. But
I can follow.
In order to, these documents cannot be retained on record.
I can follow. I can follow.
But Mr. Banerjee, why I am asking you, because if I find that the appointment of Dineshwar Rava.
Kindly, allow me, just 10 seconds time. My father has been taken to hospital. I'll just inquire how is his health. I'll just inquire.
No, Mr. Banerjee, then I am ending here.
I knew it from 2 p.m. I did not leave the court. So kindly allow me to continue.
Now, why I am asking you, what is passing through my mind is this:
yes,
that if it is found that vacancies, that these are vacancy number 32, 36 and 40 are occupied by
some people,
other candidates who do not belong to scheduled caste category.
In
that event,
the process is wrong.
Then in that event, I will direct the petitioner to add them party and serve notice.
But
because they will be directly affected.
But my lord, these vacancies, my lord, if
That's why I'm asking you, because it will take some time
True.
to do the
but
to
my lord,
complete the procedure.
my lord, what I, my lord, was my lord trying to realize, my lord, these vacancies would never have percolated to them who are down below in the gradation list. So their rights are never affected.
That is to be adjudged. That is to be considered. That is to be considered.
I can show.
But
Immediately I can show.
ultimately, if it is found that scheduled caste
There is some
vacancies were
anomaly in the process.
scheduled caste vacancies were offered to 3 candidates who are not scheduled caste category candidates,
There
then
must be
they
a
should
reason
ought
why,
not
my lord,
to
I'm
be
sure, my lord, judiciary did not commit a mistake.
they ought
I'm
not
sure,
to be
my lord,
permitted to occupy such vacancy. Only it is reserved for exclusively for scheduled caste category.
Then, my lord, in that case, they deserve a hearing. My lord, that's a different thing. My lord has indicated that my lord will add them parties. But, my lord, today we are, my lord, fighting an adversarial litigation. My lord, they are...
Let us go back to the zone of consideration.
Yes. Kindly take, my lord, page 26.
26.
Yes.
Now, how many scheduled caste candidates were there?
I'm grateful. Kindly take, my lord, the petitioner's position first. My lord, page 28.
No. How many scheduled caste candidates were there in this list of 46 candidates?
My lord, if I go by the list at 33, there were more. My lord, much more than 3.
No. This is the performance of Group T employees in the minimum fitness test.
Right.
Therefore, there are 46 candidates in the table. Starting from page 26 to 30, 28.
Covering all castes.
Including all castes.
All castes.
Out of which, how many scheduled caste candidates are there? That I want to know.
That then, my lord, I will take instruction. Sheta, I'm Jano. Then we should stop here.
Yes, then what you want to say?
Yes. Kindly turn to page 28. My lord, kindly see the petitioner's position in the gradation list.
Page 28, yes.
My lord, serial number 38, 42 and 44 are the petitioners.
Yes.
My lord, their position in the gradation list is 47. Now, how many scheduled caste candidates are here in the list? My lord, their position in the gradation list is 47, 51st and 53rd. Second, my lord, the second column is their position in the gradation list. That's the heading at, my lord, page 26.
Yes.
So, my lord, they were down below 47, 51st and 53rd. My lord, most of the other candidates, my lord, excepting these two, 54th and 57th, are above in the gradation list. Because, my lord, this chart is prepared as per the sequence in the gradation list only. So, my lord, my understanding was, my lord, these scheduled caste vacancies, 3 vacancies, could never have percolated to them.
Provided there are other scheduled caste candidates.
That, my lord, Mr. Mukherjee is true.
Suppose there are 4 scheduled caste candidates.
Then, yes.
Then 2 will be permitted to to be appointed in the promotional post.
Then, my lord, you have a difficult job before your lordship.
So how you are making this submission? I could understand that there are 10 scheduled caste candidates. And petitioner's position is 7th, 8th, 9th.
I was going by the surnames, but you know, that
so that should not be the appropriate approach.
That won't help. You know, that instruction will take and come back. That instruction will my learned senior.
You are saying that even if these 3 vacancies would have been offered to scheduled caste candidates,
then also the
on promotion, considering the position in the table, which is from page 26 to 28, that is 47, 51, 53. These 3 vacancies, yes, these 3 vacancies could not be offered to the petitioners.
That's not my understanding of.
They would not have. They could not come to the zone of consideration in terms of merit or seniority. In terms of merit, maybe, but it's a seniority come merit. Basis is seniority come merit. So in terms of seniority, it would not have been percolated to the petitioners as you are submitting. Now, it can be, this conclusion can be derived provided there are more than at least 5. Because if 4, 5, 1 will get. If this court proceeds on the premise that they are last in the list on the basis of seniority, then there must have been at least 6 candidates.
Yes.
That other 3 will still emerge over present petition.
Otherwise, my lord, the first of them will be not getting. Yes. Well, let me take instruction. My lord, my learned friend will also take instruction.
That because of the first case with the junior one, but I think after 11 days, because we're
उड़ी भी है ओ बाबा
Well, I'll fix it on 18 in that event, Thursday at 3 p.m. because this matter will take some time. I perceive that this matter would take some time. That's why today I have fixed it at 3 p.m. Now, but in the meantime, then let me direct the learned advocate to amend the cost item and add these 3 candidates.
Can you do not do that today? Let us, my lord, firstly, my lord, collate the facts. It may not be necessary. Let us not, my lord, invite them into an unnecessary litigation otherwise.
All the pleadings were filed on the last occasion.
No pleadings, my lord, report on.
That is report
from the district judgeship alone.
Report on exception. No,
From,
yes.
from the district judgeship alone.
A matter is heard in presence of the learned advocates representing the petitioners, comma, High Court administration, comma, state respondents, and you are respondent number 5, Mr. Mukherjee.
4.
And respondent number 4. Matter is heard to some length. Stop. Mr. Mukherjee, learned advocate representing respondent number representing.
আমি না আমি করিয়ে দিচ্ছি এটা জেরক্স করিয়ে স্যারকে একটা দিতে হবে আমি জেরক্স
Representing district and sessions judge Kuch Bihar has prayed for accommodation in order to obtain instruction as how many scheduled caste candidates, names of how many scheduled caste candidates, names of how many scheduled caste candidates.
Category migration.
Featured in the list of 46 candidates as indicated in the table at pages 26 to 28 of the report filed on behalf of respondent number 4. Next, 11th, you have difficulty. List the matter under the same heading. List the matter under the same heading as 3 p.m. fixed matter on December 2025. Yes.
Malad, in the report, they did not disclose any seniority list. Malad, only they disclose that if the object that is in terms of point number K of the objection, it is to be mentioned that the seniority list of employees of the judgeship was duly published in the year 2023. And Malad, they say crave leave to produce the photocopy of the.
Have you taken this point in your petition?
Malad, that was in their report. Malad, I am praying on a seniority list, maybe. Malad also produced.
It is necessary. Seniority list has to be checked out because it is also on behalf of High Court administration. It is submitted that a seniority should be the basis.
Yes. For that reason, Malad, the seniority list.
Since it is a promotion based on seniority come merit,
yes.
So seniority must have been the basis.
My client will be the senior. Malad, then everything will be clear in the next.
Take this point. Can you? হ্যাঁ একই দিনের রাত তাহলে একটা আলাদা করে অর্ডার করে দাও আইটেম নাম্বার 34.
But this order would cover both.
Item number 34.
Page numbers may not tally.
দেখি
বলেছেন জজ সাহেব 26 নম্বর পাতা থেকে 28 নম্বর পাতা
আইটেম নাম্বার 34 টা দেখো
প্রশান্ত আইচির রিপোর্ট আমাদের ফাইলটা দেন
due to paucity of time.
Oh, আচ্ছা.
Due to paucity of time, matter is not heard today. Matter could not be heard today. List the matter under the heading under the same heading as 3 p.m. fixed matter on 18 December 2020. I'll consider it.
Great.